This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C311. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C311.
Good afternoon. Thank you to everyone who has joined us. And as always, why don't we begin with a quick introduction, name and organization or affiliation, and we can then get started. We have a pretty full agenda this afternoon, but why don't we start to my far right and have some quick introductions.
Hi, Mark Flynn for the Virginia Municipal League.
Renee Pulliam with the Virginia Apartment Management Association.
Elizabeth Steele with Kensington Vanguard Land Title.
Bob Bradshaw with the Independent Insurance Agents of Virginia.
Andrew Clark with the Home Builders Association of Virginia.
Troy Garrett, the Executive Director of Virginia Association of Housing and Community Development Officials.
Monique Johnson, Virginia Housing. David Bolivar, representing the 11th District in the House of Delegates, City of Fairfax, parts of Fairfax County.
And Ghazala Hashmi, representing the 15th Senatorial District, which is parts of the City of Richmond and Chesterfield County.
Elizabeth Pollen, Virginia Housing Commission.
Ashley Welburn, Welburn Management, gubernatorial appointee.
Erin Corman with the Realtors.
Randy Grumbine, representing the Virginia Manufactured and Modular Housing Association.
Good afternoon, Joe Lurch, representing Virginia Association of Counties.
Good afternoon, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association.
Kelly Harris Braxton, Virginia First Cities Coalition.
Laura Dobbs with Housing Opportunities Made Equal of Virginia.
Brian Kozu with the Virginia Housing Alliance.
Thank you, and we may have Delegate Danny Marshall online. Delegate Marshall, are you joining us online? Perhaps not, and I know Senator Mamie Luck will be joining us as soon as the other commission meeting is finished. But why don't we go ahead and get started? And first on our agenda is an overview of our agenda provided by Elizabeth Pollen, our Executive Director.
Good afternoon. Thank you for each of you for joining us this pre-Thanksgiving afternoon. I'm going to give you all a brief overview of what the meeting will encompass. First, we'll hear a brief presentation about a new organization in the Commonwealth to promote affordable housing. This organization was brought to our attention by Liz Steele, one of our workgroup members. Next, we'll hear from proponents of proposed legislation, some topics that we've discussed in prior meetings, as well as small groups and others where the legislators are bringing forth their issues for the first time today. Each of you will have the opportunity to vote yay or nay to advance the legislation onto the full commission for endorsement. The full commission will meet on Tuesday, December 17th at 1 p.m. here in this same room. We're going to rearrange the schedule slightly and allow Senator Russett Perry to be first among legislators, and then Delegate Phil Hernandez to begin the discussions. Delegate William Graves is unable to attend today and does not have legislation going forward. Joe Lurch and Laura Dobbs will discuss the draft of the Affordable Housing on Religious Properties bill that is part of your packet. And then Senator Hashmi will present another option worked on outside of the commission. Delegate Bolivar would like to add a budget amendment that would provide funding by the Commonwealth for pre-construction costs for religious entities and others. He will discuss that inclusion. Welcome, Hope Rudder.
Good afternoon. My name is Hope Rudder, and while your agenda might say that I'm from Virginia Housing, and I am very proud to be part of that organization, today I'm coming to you as president and co-founder of the Greater Virginia Women's Affordable Housing Network. With me is Elizabeth Steele, as you may know her as one of your work group members. To me, she is one of our board members and a founding member. Thank you very much for letting us speak today. Greater Virginia One, or GVA One, is a state chapter of National One. National One was started in 2007 in Atlanta, Georgia by a group of women, and then became a nonprofit in 2014. In 2021, they grew into a larger group to become the National Women's Affordable Housing Network. Their mission is to have a chapter in each state, and they have grown to over 30 chapters. We at Greater Virginia One thought that Virginia could only benefit from this chapter, and so we brought it here. You may be asking why you have not heard of us before, and that is because we only just formed earlier in the year. We just received our formal 501c3 in January. We are a board of 9 that will grow to 15. We are a women-led membership group, and our mission is committed to the development of women and allies in the affordable housing through partnership, education, and service across the Commonwealth of Virginia. Our vision to meet this mission is to create a strong network of women and allies across the Commonwealth of Virginia through networking events, education seminars, webinars, membership programs, and ambassadorship. Membership is free, and through the Greater Virginia WAN, we will be creating for women 15 industry leadership positions that include board training and over 40 positions on committees. Our members will benefit from coaching from female industry leaders, connections, industry updates, and in the future, we will be creating a scholarship program for certifications, continuing education, and attending conferences to promote our vision of a strong network. So why are we talking to you today? We aren't lobbyists, and we're not asking for money. Our reason for speaking with you today is to make the work group aware of who we are and that we are here, and that we are available to assist the Commission in the empowerment of women in affordable housing, as well as serve as tools to the Commission if needed. According to McKinsey & Company, this is a look at the 2024 corporate pipeline. And while you may not be able to read all the details on this slide, it really illustrates that women remain underrepresented and this gap persists. Even though women make up a greater percentage of number in the workplace, they are grossly underrepresented, and especially so in the housing industry as a whole. Virginia is no different. According to U.S. News, out of the population of Virginia, only 33.2% of women hold top executive roles. On this slide, you can see evidence from the last census study that only 16.7% of the architecture and engineering and only 3.7% of the construction are female. These are the two top industries in affordable housing. While business and finance that isn't managerial and office and admin support are dominated by women. It is our duty and our responsibility to not only get women into these trades and industries, but also get an equal representation at the leadership level. Now I'm going to turn it over to Liz for more information.
Thanks, all. Well, I think it goes without saying how there's a pretty large gender disparity between men and women in industries across the board. However, the reasons for that are really not known. The bottom line is that that despite the fact that women make up more than half of the hires in the workforce, the question of what's disrupting their career paths remains unknown. And figuring out the why is what we're here to do. Once we figure out the why, then we can decide on the appropriate path forward and helping women become more effective in the affordable housing and in industries in general. And this would be some proposed roadmap to remove barriers. Some of the committees that we have, we've got 9 board members and 3 committees, and these are a list of the committees that I think that are aspirational for us. The events committee, of course, is self-explanatory. We want to have networking, regional networking events so that we can provide opportunities for women who don't already have those opportunities to meet and to speak with like-minded people. The impact committee would be service and nonprofit work, and that's an aspirational committee for us at this point. We have an ambassador committee, which would be having people from different parts of the state represent each portion of the state. Our membership committee is self-explanatory. Our communications committee, it would be consisting of putting out newsletters, engaging in social media and press releases, etc. Our professional growth would be lunch and learns and other sorts of seminars to promote education among the membership. Sponsorship is, of course, obvious, and allyship is probably one of the most important committees that we have, and that we have one ally right now in the Greater Virginia WAN. The Ally Committee is made up of male allies in the affordable housing industry committed to elevating underrepresented voices. Basically, we need to promote women like the future depends on it. According to multiple studies done by Freddie Mac, men and women at financial services companies often start out in fairly equal numbers, but men still dominate leadership positions, holding over 80% of the roles, with the profit and loss responsibility. The consequences hurt both men and women in the future of the industry, since numerous studies highlight that companies with gender-diverse executive teams see greater profits and attract better talent. So both men and women sponsor from mentors, both benefit from mentors and sponsors as they advance in their career. It doesn't matter whether they're men or women. The raw numbers tell us that with men dominating the executive roles, their advocacy and inclusion is critical to getting women into higher ranks. This is why having an ally is so important. What we've been able to accomplish this year in the 5 or so months that we've been around is listed above. Obtained a state certification, registered with the Department of Agriculture. We participated in some statewide conferences and one national conference, co-sponsored meet and greet happy hour, and we've done multiple speaking events and helped raise funds for an affordable housing nonprofit. And the plan for 2025 is to host at least 4 lunch and learn events, have at least 2 networking events, and these would be things that would be available for members across the state. Engage in quarterly membership calls, attend multiple conferences, create and foster the ambassador program, which is having representatives in each part of the state, attempting to create a mentorship program to help younger women and those still in school get involved in affordable housing, and participating in events to benefit Virginia affordable housing. If you're interested, please check out our website, and if you're interested in joining, please know that it's free to join. Thank you very much for your time.
Well, thank you both for your presentations, and I will open the floor if there's any questions or comments from any of our work group members here today. Seeing none, I thank you again for a presentation, and thank you for the work that you're doing in this very important space.
Thank you.
Thank you. Okay, we will then move into our consideration on legislation, and our first legislator to present is Senator Russet Perry on the Virginia Residential Landlord and Tenant Act. And the bill is in your packets for our work group members. Senator Perry.
Yes, good afternoon, members, chair, members of the commission. This is a bill that I think that we looked at the last time that I was here a few months ago. Just as way of a reminder, what the bill does is the bill seeks to amend Code Section 55.1, 1236 of the Code of Virginia. As the law currently stands, the law permits for early termination of residential leases only if there is a conviction in a crime of sexual abuse or criminal sexual assault or family abuse, or if a permanent protective order has been issued. The bill, the amendments that I'm seeking to introduce do a couple of things. But primarily the issue is that often these types of cases, particularly the more complex cases, drag on for years before they can be adjudicated in the courts. My background is as a former domestic violence, sexual assault prosecutor, and so we know that it can often take years for these cases to go to trial. And so the whole point of the bill, as it stood, the whole point of the law was to help victims of some of the most horrific crimes that we have here in the Commonwealth be able to terminate their leases early so they can escape their abusers, go move somewhere else, move out of the area, and provide protection. But unfortunately, the way the bill is now, you're talking about years-long process when their lease probably wouldn't be in existence anyway. And so the bill really doesn't do a whole lot. The same issue arises with a permanent protective order. Any prosecutor, and I'll speak for myself, I'll say worth their salt, is never going to let a protective order hearing to precede a criminal trial. And the reason for that is we do not want victims up there testifying multiple times about what happened is bad for the victim. These are just evidence-based practices for best practices and how to deal with victims. And it often is hurtful to the criminal case if we have victims up testifying multiple times, which they will do anyway in the course of the process, but there's no reason to allow that case to proceed. So the protective order, the permanent protective order portion of the statute really does not a whole lot of good either, because that protective order generally trails along behind the criminal case. And so in looking at the statute, there was a victim who came forward and ran into this exact issue. I need to terminate my lease. I am in danger. I am a sitting duck here, and I can't afford to just pay for multiple apartments in multiple places so that my abuser doesn't know where I am all the time. So what my bill seeks to do are a couple of different things. And basically what it does is it tries to back this idea up in time so that it actually could be effective for a victim of domestic violence, sexual assault. I added stalking in here. I think that was left out, quite frankly, inadvertently. Those are some of the most dangerous cases that we see for people who are sitting left in a house where the person who is stalking them often knows where they live. And I added in human trafficking as well. So you should see that in Part A of the first section of the bill, 55.1-1236, the addition of those two charges to family abuse and sexual assault, sexual abuse. In addition, the way that this bill backs up in the timeline, what it looks at is for those of you who are familiar, in Virginia, we have 3 different kinds of protective orders: emergency protective orders, preliminary protective orders, and permanent protective orders. So we've already talked about that permanent protective order class. This bill seeks to back up the time when you could seek a protective order to the point at which an emergency protective order is issued, or a preliminary protective order, or a permanent protective order. They can seek at any of those point in times to go to their landlord and provide that 30-day notice of termination. They do have to provide 30 days, and they are responsible for that last month of payment in any event. So they're not, quote unquote, getting off the hook. They still are responsible at that point in time. This bill also backs up the time from, we're not looking at a criminal conviction, we're looking at when a charge is issued. That charge can be issued by a magistrate, that charge can be issued by a grand jury, that's through the form of indictment. So back when a charge is issued, when probable cause is found that a crime that is alleged, one of these, sexual abuse, you're talking about rape, object penetration, domestic abuse, stalking, human trafficking, if any of those charges, the ones specifically laid out here, if a magistrate or judge, judicial officer, or a grand jury has found that there's probable cause that those crimes as alleged have occurred, then at that point in time, once that document, a warrant or a summons or a indictment or an information issues, then at that point in time, that individual can take that document to their landlord and say, hey, I'd like to provide 30 days notice that I intend to terminate my lease. I'll tell you all also that whenever I started looking at this issue, I noted that several other of the surrounding states actually are more, have other protections in place. We know that a large number of victims of these types of crimes never come forward. They never go to police. If they do go to police, it's much further along the process through the number of times that they have been victimized with these types of crimes. And so several other states, to counteract that, have allowed other people to essentially write letters on these victims' behalf. So that would be people like domestic violence advocates. That would be people like psychiatrists or doctors who these people go to, victims go to and say, hey, this is what's going on in my house. This is what's going on in my intimate partner relationship that I have. This is what's going on with my significant other. And they will write a letter, and that in several other states has been deemed sufficient to then go to your landlord and provide notice that you would like to terminate your lease under these provisions. I'm actually not seeking to do that at this particular point in time. Not that I'm opposed to it. I actually think it's a great idea. I think you would reach a lot of people in that way that are hidden behind the scenes. But I was, as a point of compromise in expanding the statute, looking at an issue where we have a neutral third-party magistrate or a neutral judge or a grand jury, someone who has no interest at all. At least at that point in time, I hope to find consensus that that would be enough to go ahead and satisfy this this commission. I will, by way of, I'll tell the commission that that I did. I will. Well, I'll just remind. Well, I met with Bill Stanley, who is not Senator Stanley, who is not here today apparently. And I also met with VAMA and AOBA. The last time I was here, Senator Stanley brought forward, who also happens to be an attorney, I know you all are aware, and we sort of had a back and forth about some of the issues. He sort of wanted, quote unquote, a judge to have eyes on this before, one was issued. He had like some issues he raised. He and I met again with these other groups, with Ms. Ahmed, to discuss this. I pointed out that preliminary protective orders have judges' eyes on them anyway, so that sort of removed, to my understanding, Senator Stanley's concern about that issue. We then went back to, obviously, to protective orders or emergency protective orders, and I think he ended up coming off of that too, and I think that was based on the idea that, first of all, emergency protective orders can be issued by a judge or a magistrate. And secondarily, that magistrates are the same folks that we entrust to issue warrants to deny people bond, to take away people's firearms, through red flag orders, to issue emergency protective orders, to issue emergency commitment orders, to take away people's liberty to go to a psychiatric hospital to be evaluated. We entrust them with a whole lot of things. And to include, as I said, people's liberty, to lock them up in jail and hold them without bond for days on end. And so I'm not quite sure why they wouldn't be trusted to issue a protective order, and we should be able to evaluate that issuance and hold that to the same standard as we would a judge, a judicial officer. And just for the members of the commission, to have a protective order issued, the standard for that is that a judge or magistrate has to find by a preponderance of the evidence that this individual is someone who, within a, quote, reasonable period of time, is subjected to an act involving violence, force, or threat that results in bodily injury or places that person in reasonable fear of death, sexual assault, or bodily injury. And I can tell the members of this commission from my own experience, is actually a very high standard to meet. There are plenty of things where you would look at it and say, this person should be afraid, this is not safe, this person is not safe, and that person will be denied a protective order. And I speak from my own personal experience, not my personal experience, my personal experience representing clients. I serve as a defense attorney, a civil attorney in my current life. I will just say, just to read for just a second, as I said earlier, the reason that I think this matters, maybe someone would say that, you're talking about, probably the difference in, a couple of days or something like that. I'll just remind the members of this commission, who I know are probably familiar with this, but I'm pulling this off of the Emory University School of Medicine. And it runs through domestic violence, intimate partner violence. This bill would include boyfriend, girlfriends, people in high school, if that were to be the case, an 18-year-old. But Emory University School of Medicine says that every year, 5.3 million incidents of intimate partner violence occur among U.S. women aged 18 and older. Intimate partner violence results in nearly 1,300 deaths and 2 million injuries every year in the United States. More than 3 women are killed by husbands, boyfriends, and intimate partners every single day in the United States. 1 in 3 women worldwide has been forced into sex, beaten, or otherwise abused another way during their lifetime. Women aged 16 to 24 are most likely to be victimized by an intimate partner. Most intimate partner incidents are not reported to the police. Only 20% of rape, sexual assaults, 25% of physical assaults, and 50% of stalking towards women are reported. I think that and then the last thing here is that the period of time which is most dangerous for intimate partner violence to escalate, for it to result in someone's loss of their life, are in the moments when they're leaving. And I think that's particularly relevant here. because this bill seeks to back this up to when an emergency protective order is issued, that is the point in time, or when a criminal case is issued, that is the point in time where you have third parties, eyes on that person, eyes on their complaint, and it's the earliest point in time where that is the case. And that person at that particular point in time, according to this bill, would be able to give that 30 days notice, during which the apartments can come, show their apartment, show it to other people, that's already provided in law, and they still get that money back for those 30 days. That money, they can get that from the tenant. So that victim is still going to have to pay for those 30 days, even if they can then move out. They're going to still be responsible for those 30 days. So it's not an immediate fix at that point in time, which I would love for it to be. It's not what I'm asking for today, though. I am asking, though, that you vote on the bill as it stands before you, and I'm more than happy to take questions.
Thank you, Senator Perry, and we will open the floor for any questions or comments from our work group members. Bisma, yes.
Thank you so much. And thank you, Senator Perry, for bringing this issue forward. We really appreciate collaborating on this important issue, especially to ensure that documentation can't be misused for fraudulent lease termination. Unfortunately, that's a loophole that we don't want to include. And so we spoke to our members about supporting that preliminary protective order that you spoke about. We have opposition to that emergency protective order because it doesn't go through the court, but since that preliminary protective order does, our members were more comfortable with that. Similarly, last session, we worked on a similar bill with Delegate Delaney for lease termination for sexual assault survivors, and I think that's where we landed on as well, was that preliminary protective order. And so hopefully, because that preliminary protective order goes through that court, we can hopefully move forward with that as a good measure if you're comfortable with that. But our membership kind of decided that would be an appropriate measure on our end.
If I could just respond, Madam Chair.
Sure.
Yes, please go ahead, Senator.
Okay. I would just point you to Virginia Code Section 19.2.152.8, wherein it's entitled Emergency Protective Orders Authorized. And it actually references specifically any judge of a circuit court, general district court, juvenile and domestic relations district court, or magistrate may issue an oral or ex parte emergency protective order. So I think it's a little bit of a misstatement to say that emergency protective orders are only issued by magistrates. The code specifically provides for other instances where they can be issued by a judge.
Thank you. I think Delegate Bulova, and then we'll hear.
Thank you, Madam Chair. And two items. The first one is just because I'm not a lawyer and I hadn't seen the word used in this term, but warrant, summons, information, and indictment. So 3 out of those 4 I understand. So what does the information refer to in that case?
The information is, quite frankly, uncommonly used way for cases to be brought in circuit court. It's something I've actually never sought an information. I've seen it sought once. It's basically the prosecutor's office goes before the judge and says, "Hey, here's the information." I believe they have to swear to it. It's just an additional way to bring a charge that's not commonly used, but I thought it would be remiss to leave it out.
And Madam Chair, I guess the second question may be more substantive, maybe not an issue at all. So on line 20, where you struck out, court has entered an order convicting a perpetrator and then added the additional language in there. I guess the issue that I'm wondering is whether we want to throw in there before warrants and summons and information and indictment, whether something along the lines of active is in order, right? Because, again, unlike some of these other ones where there's some rigor, some of these other ones very well might not pan out and could kind of linger out there without any follow-up. So anyways, didn't know if the word active or whatever term would kind of describe that these are things that actually are current, as opposed to something that was 5, 10, 15 years ago that were never acted upon. If that indeed is a point, I would probably unstrike the first part, right? Because the entering a conviction, that's a definitive thing. And then maybe saying active with respect to warrant summonses and indictments. But again, I might be barking up the wrong tree. It might not be an issue. Just wanted to ask the question.
Madam Chair.
Senator Perry.
Thank you, Delegate Bulova. I guess my thought on that would be would be this: the way this bill reads, or at least the way that I read it, is that you're talking about a perpetrator and a victim, a specific set of folks together. And so I think that if you go back, and I think your concern is basically, hey, if 10 years ago my intimate partner strangled me, for instance, and a warrant was issued, and 10 years later I'm in a lease with that individual, the case never proceeded, maybe I'm a reluctant witness, maybe I declined to participate for whatever reasons, which is common. Then 10 years later, myself and my intimate partner are in a lease, and I go to my landlord and say, hey, here's this charge from 10 years ago. So your suggestion is like we should have that it's quote unquote an active document or a conviction. I guess my question would become, if you're seeking that it needs to be something that is essentially current or ongoing, which is sort of how I take your question, and I apologize if that's not what you're trying to get at.
I think, Madam Chair, I think you're right. For something that is this old, hasn't been acted on, certainly ongoing, but not necessarily current. And so I don't know what the legalese in terms of something that is actively being considered, as opposed to like your example. Something may or may not happened 10 years ago, warrant was issued, nothing ever became of it. And do you really want that to be able to be used 10, 15, 20 years down the road in order to be able to break a lease? And again, that's probably something that doesn't happen very frequently, which is why I'm hesitant to muddy this up, if others feel this is pretty solid. But that's the only thing that leapt out at me.
I'll just say, whenever you go to add back, and the thing that occurs to me in the hypothetical, I think it's a fair hypothetical, except for whenever you're talking about adding back in the language about convictions, the same could be true, right? My intimate partner could be convicted of stalking, right? And I think under yours, then it wouldn't be an active conviction. There's no such thing as an active conviction. It's just a conviction. And so my intimate partner could strangle me or assault and batter me, right? Be convicted of that offense. 10 years later, I think under your hypothetical, I could still take that to my landlord and still terminate the lease, because there is no such thing as an active. I don't know how to legislate if you add back in convictions, right? I guess you could say active warrant, information, indictment, or summons. But I don't know about the conviction portion of that, and that could still be the case, as we know many people who are abused go back and live with their abusers. And I guess from a policy perspective, my thought on that is that if 10 years down the line, a person who's been abused decides that they're ready to leave, I think I would support them in that.
I appreciate that. Thank you.
Yes.
Please go ahead.
Thank you, Madam Chair. Two things, just following up on that conversation, perhaps, and I don't know if this is the answer, but I just jotted it down, tying it to something that has happened during the lease term may be a way to do that. The lease term could be many, many years, or while they're living on that property. I don't know, might have to figure that out, but that might be a way to kind of get at the active requirement. The second thing, I had a question, and maybe you can explain it a little bit more about the emergency protective order. I know this was something that our members were concerned with last year in Delegate Delaney's bill. Is the emergency protective order, it was my understanding it's only good for 48 hours. And if that's in fact true, then what happens after that? Is it just a stepping stone to get to the preliminary? What is the process there?
Madam Chair, Ms. Corman, to address the first part, I think that may be true if we tied it back to during the term of the lease. One of those things, I think that may satisfy the issue. As relates to emergency protective orders, no, emergency protective orders are 72-hour orders. And so what happens then is in 72 hours, the victim is responsible for petitioning for a preliminary protective order. So if nothing happens, the emergency protective order is dismissed. If a preliminary protective order is petitioned for, then we have a preliminary protective order. Those are done ex parte as well.
Follow up, Madam Chair. So if the preliminary is done ex parte as well, in your experience, is there a long delay in getting a preliminary once the petition is made?
No, the code lays out that these take precedence on the docket. Okay. So if I have an emergency protective order that's granted, then I have to then go to the court, for instance, and either way, I have to be in the court. I have to come back to the court in 3 days. It's kind of an arduous process for what that's worth. You're putting a lot on this person. And fill out other paperwork to petition for a preliminary protective order. Then that is then reviewed by a judge. Different courts do it differently, whether or not they require the person to come in and testify, but the person has to show up at the courthouse and go ahead and fill out that paperwork again for the judge then to issue a preliminary protective order. I think the reason this matters, and I think there's a fair argument or an argument that can be made. I don't actually think it's fair, but hey, Senator Perry, Russet, whatever, you're talking about 72 hours here. What does it matter, right? And I'll go back to the points that I made earlier. And those points are that, one, the person who's issuing this, whether it's either a judge or a magistrate. So I think that matters, right? We have a neutral third party. Two, I think time is of the essence when these things are issued. And we had a case up in Loudoun County not too long ago where an individual strangled his wife, was subsequently granted bail on a GPS monitor and went right to that house and bludgeoned that woman to death. And so I think 72 hours matters. I think it's a big deal. And so that would be my position on it.
Thank you, Senator Perry. Are there any other comments or questions? Yes, please go ahead. I'm sorry.
Thank you, Madam Chair. Renee Pulliam, Virginia Apartment Management Association. Thank you for being here today. The comments from Delegate Bulova and Ms. Corman, I agree that having something that is currently active or at least tied to the term of the lease agreement would make this more palatable, because the way that it's currently written, a landlord is in a position to terminate, or the victim, in this case resident, is in a position to terminate a lease agreement by actions done to them by a third party that has nothing to do with the landlord's contract with this resident. So we currently have in place certain protections in the law. So the points that they've made about how this ties to the existing lease agreement, I think, are pertinent. We would have no way to know what's happening in their personal situation. It's not really for us to decide anyway. It's, we have a lease, it's a legally binding contract. So when someone who is a third party does something to one of our residents, and that gives that resident the right to terminate their lease agreement, that leaves the landlord really in a position, if this is something, like I said, from 15 years ago or what have you.
Madam Chair.
Please.
If I can, I think, a couple of things. One, I think that the law as it's written does that anyway. And I think this is probably a law that you guys all are aware of and maybe even voted on previously. But two, I'm not opposed to what Ms. Corman said about linking it to the active lease. I think that makes sense. I think the easiest way to do it is as she proposed. If there is a emergency protective order, preliminary protective order, permanent protective order, charge that's issued, or charge that's issued, if one of those things happens during the period of your lease, I think that makes sense. I think that's a way to tie it back to the active. The point is not like to try to, to be honest, I can't imagine that happening, but I mean, I get it. I'm a lawyer, sure, write the law the way that you're intending for it to be as much as you possibly can. So I'm not opposed to that issue.
Thank you. We have a few more. We'll hear your comment first, and then Laura.
So, Madam Chair, Senator Perry, your comments kind of did address what my question was. I was trying to kind of think through how this might be operationalized. So I know we have VAWA, Violence Against Women's Act, and I know a lot of property owners, or at least in the affordable space, know how to navigate that, know how to help individuals in their properties who are having this issue, and then use that guidance in order to drive how they kind of deal with getting them out of the property, out of the lease. So I'm just trying to kind of determine what the intersections are between that and what's being proposed.
That's a great question. I'm familiar with VAWA too. I don't think VAWA covers these covers this, and the reason I don't think so is that the woman who brought this to me was unable to terminate her lease under current federal law. And so that was part of the precipitation for the bill in the first place. But yes, I know on the federal level, yes, of course, there's they try to enact as many protections as they possibly can, but I think it's why you see differences in New Jersey, Delaware, Virginia on this exact issue, is because it's just not extensive enough to cover a variety of situations.
Thank you. Laura?
Thank you, Chairwoman, and thank you, Senator, for bringing this bill. I had a question about what is covered under the definitions in Section A. I'm not a criminal law attorney, so I'm not quite familiar. I'm going to ask this. We have a lot of clients who come in where the harassment is coming from the landlord or an employee of the landlord, such as soliciting sex in lieu of paying rent, and if that type of offense of solicitation would be covered under these definitions. We have the Fair Housing Act that provides protections, but a lot of that is retroactive relief and doesn't act quickly enough to get them out of the lease in the first place.
Madam Chair.
Please
Okay,
go ahead.
you're gonna have me put on my prosecutor hat for just a second. I'm gonna have to think back through. If someone's soliciting you for sex in lieu of paying your rent, I take that as a question. Then I think what you would charge them with is probably some form of probably bribery or extortion, one of those crimes. And off the top of my head, I think the answer to your question is going to be no. I don't think it would be covered in here. I'm not opposed to it. To be totally fair, there are going to be other instances that are not covered under here that we probably could all agree probably should, right? For instance, this isn't going to include if my boyfriend comes and won't let me leave or whatever, it comes over and starts, damages my car because he's mad at me because I broke up with him, right? Maybe I could get a protective order, maybe not, right? Depending on what my evidence is that he was the one who did it, right? But let's say he's smashing my windshield, I can't go to work anymore, right? Lots of things that could fall out from this intimate partner violence. That's going to be charged as destruction of property, which is not one of these enumerated offenses, although it is still intimate partner violence. So these code sections are not certainly perfect, and I take your point. To be totally honest with you, I haven't encountered that situation as a prosecutor, and I want to go back and look at bribery and extortion. They're kind of weird statutes. They don't always cover everything we want. And those kinds of situations are exactly what I'm thinking of that they don't always cover. So I would have to go back and look at them specifically to see if they would cover that situation in the first place. But that's the first place my mind goes. But I think it's a great question.
Thank you, Senator. And just from listening to the conversation, it seems like there may be some recommendations and tweaks that can be made. Our goal here today is to determine some recommendations that we will be making to the full Housing Commission for the December meeting. And we still have time to continue to work on legislation and make any edits or changes as recommended by either the work group or the individuals you've been working with in the smaller work group as well. But just to get a temperature of whether we want to move forward with a recommendation to the full Housing Commission as to whether or not this bill is one that the Housing Commission wants to put a stamp of support as we move into the next session. That is the kind of question in front of this work group. Is there a motion regarding this proposed legislation?
Madam Chairman.
Yes, please go ahead.
Bob Bradshaw with the Independent Insurance Agents. I guess that is the question is, as a procedural question, could the commission support the public policy interest of the bill, but our recommendation would be that it go to the courts committee to iron out the issues that, frankly, I have no idea how they would.
We can certainly make that recommendation, but of course, the assignment of legislation to various committees is in the hands of the clerk as well as our leadership, and any legislation can always be re-referred if necessary by the committee once session begins. But I think the question for us is whether or not this work group offers recommendation of support to the broader Housing Commission when we meet in December.
Madam Chair.
Can I speak just a second?
Yes, Director Pollen.
So Senator Stanley is not able to be here today, but he was in agreement with Senator Perry that all participants agreed to both stalking and human trafficking for early lease termination. That was also AOBA's agreement. And he also agreed that lease termination can proceed if a perpetrator is held without bond, enabling the victim to terminate the lease without waiting for that lengthy process. And I can't speak for Senator Stanley on things, but during this particular meeting, he wanted the bill to move forward with these points.
I will speak for Senator Stanley. Obviously, I was in the meeting with him, and I have spoken to him about this bill subsequent to that. And his comment was, quote, "The Republicans will be supporting Senator Perry's bill. It's a very good bill," for what that's worth.
Is there a motion?
Madam Chair.
Delegate Bulova.
Thank you. And I mean, this has come a long way, and so I am fully supportive of having this go to the Housing Commission with a recommendation, realizing we can recommend to the Housing Commission, they'll ultimately take action, based on the final form of this. So hopefully the feedback's been useful. For me, I think the idea of adding in during the term of the lease, I think is a really elegant way of kind of getting at the timing issue. And quite honestly, if you have that language in there, I don't see why we would need to take out a court as entered and order convicting a perpetrator. I would leave it to DLS or smarter people than me to get the construction of that correct. But I think adding that back in and then talking about the term of the lease, I think that makes it pretty solid, and it makes it timely in terms of what's going on. So anyways, I would make that motion.
Thank you, Delegate Bulova. We have a motion on the floor. Is there a second? I see a nodding head. Okay. Yes, please go ahead.
Can I just clarify or have someone clarify what the motion is? Is the motion to present this language as written, or the motion is to continue working and present the concept? It's that? Okay, thank you.
Yes, and again, we are a work group and we are making recommendations to the full Housing Commission. The actual vote will be taken in the Housing Commission itself. So we have a motion and a second, and again, we'll just do a voice vote to make the recommendation to the December Housing Commission. All in favor, please say aye.
Aye.
Any opposition? Any abstentions? We will be making that recommendation to the full Housing Commission in December. Thank you, Senator Perry.
Thank you, Madam Chair. Thanks, members of the committee.
We will move on then to our next item of legislation, and that is Delegate Phil Hernandez with flood-related disclosures.
Good afternoon, Madam Chair. Good afternoon, members of the work group. I want to start by saying thank you, because I'm back here again with a new version of my flood disclosure bill, but wanted to say thank you because I have tried and endeavored over the course of the last few months to connect with, I think, nearly each and every single one of you one-on-one to hear your concerns, comments, questions about this legislation and the state of the law. So the version that you have before you tries to incorporate all of that feedback that I heard over the last few months. The heart of the bill now is really on the last page, page 7, beginning on line 168. And in this new paragraph, essentially we are requiring a disclosure by the owner of real property when the owner has actual knowledge that said property exists in the 100 or the 500-year floodplain. So we think this takes a meaningful step forward. to better protect consumers in Virginia, and at the same time uses the same actual knowledge touchstone that already exists under current law in paragraph A of the same code for repetitive loss. So again, thank you for the collaboration on this. I don't think there is any opposition, although I will knock on wood. I'm happy to entertain any questions or comments, but I hope that the work group will support and endorse this legislation. Thank you.
Thank you, Delegate Hernandez. Are there any questions or comments from our work group members? Yes, please go ahead, and please remember to turn on the mic. Yes, thank you.
Thank you, Madam Chair. Erin Corman with the Realtors. We just want to thank the delegate for spending so much time with us and working with us on this language, taking our concerns and our members' concerns into consideration. We really do appreciate it. We have not been able to present this language as it is now to our members. Our policy committee does not meet until December. So at this point, we are not able to support the bill on the record, but we have worked closely, we have tweaked language, and we'll continue to do so. Just don't want our silence to go as as support at this point, because we can't do that until our committee meets and reviews the language.
Thank you,
Thank you.
understood. And when we come to a vote, you can abstain if desired. Any other comments or questions? Okay. Seeing none, we can entertain a motion as to whether or not this work group will recommend moving forward to the full Housing Commission.
Madam Chair, I'd so move.
It's been moved. Is there a second?
Second.
It's been moved and seconded that we make that recommendation to the full Housing Commission next month. All in favor, please say aye.
Aye.
Any opposition? Any abstentions? One abstention. Thank you very much, and thank you, Delegate Hernandez.
Thank you very much.
So, yes. So now we're going back to the original flow of the agenda, and we will hear from Senator Sturdivant, SB 693, and that too is in our packet.
Thank you, Madam Chair, and good afternoon, members of the commission. Senate Bill 693 was a bill that I brought last session, and the idea is to prohibit large hedge funds, investment firms from buying up large numbers of single-family homes around the Commonwealth of Virginia. This is something, it was a bill that was brought at the federal level in the United States Senate and House of Representatives by, I believe, 2 Democrat legislators, and hasn't really made much progress, unfortunately, in the United States Congress. But it is an issue that does not affect Virginia as badly as it does affect some other places around the country, but it is still an issue that has an impact on Virginia and the affordability of housing single-family homes in Virginia. This is from, as of August 15th, 2024, this is from Redfin. They reported just a couple of months ago that since 2023, investors bought 1 out of every 6 U.S. homes that were sold nationwide over the past year. That's $43 billion worth of properties. And it's actually 1 out of every 4 low-priced home that was sold was bought up by one of these large hedge funds or investment firms. And they report the top 50 metro areas based on population. And we have 2 of those here in Virginia. We've got the Washington metro area, and then we have Virginia Beach. So from 2023 until 2024, in Virginia Beach, 11.1% of the single-family homes that were purchased by hedge funds, investment firms. And the median price of the home, single-family home that was purchased by those large institutional investors was $195,000. That was the median purchase price of those single-family homes. So these are the affordable homes that your average everyday Virginian that would otherwise be bidding on and trying to buy, but they're being sucked up by these large institutional investors. Same goes for Washington, D.C. Metro. In the same time period, 23 to 24, second quarter of each year, 8.7% of the single-family homes in the D.C. Metro were purchased by these institutional investors. And the median price of those D.C. homes, D.C. area homes, was $471,000. And so for D.C. Metro, that's an affordable home. And again, that's the median. So they're getting lots of houses that are below $471,000. So that's the issue. That's the problem. As I said, there are some states where this is much worse than it is here, but we don't want to be the next target of a lot of these institutional investors coming in and buying up even more houses. So my bill last year was more complicated than it needed to be. The general idea is let's stop these folks from buying these houses in Virginia. And I had provisions in there that the county clerk of court would have to report to the Secretary of the Commonwealth if they saw a problem, and the Secretary of Commonwealth would have to report to the Attorney General's office if they saw a problem. And so in talking to folks and trying to streamline this and make it more simple, I just took all of that out. And so the bill that is before you in your packet and that has been redrafted for this coming session is a lot simpler. And what it does is it defines what a prohibited business is. And so that's identifying the investment firms, the hedge funds that can't buy these single-family homes. We used a dollar figure from the federal legislation, so it's a hedge fund or private equity firm that has $50 million or more in value or under management. But what it specifically excludes is we are excluding nonprofits and we're excluding organizations that are engaged in the construction and the rehabilitation of single-family homes. So they are not covered by this. They're not meant to get involved in this. They can continue to invest in rehab homes. So we're not doing anything to nonprofits, and we're not doing anything to new home builders or rehabbers. It's really to be focused on those private investment firms. And then the important part of the legislation is down on lines 45 to 48, and it just says that no prohibited business shall acquire an interest in a single-family home in the Commonwealth on or after July 1, 2025. So it would go into effect this summer. The other thing that my bill did last year was it made any single-family home that had already been purchased by one of these hedge funds, they had to divest it and put it back on the market. And so with the intent and hope of trying to find peace in the valley here, this is going to be prospective only rather than retroactive. But that's the bill, Madam Chair.
Thank you, Senator Sturdivant. Are there any questions or comments from our work group members? Delegate Villava.
Thank you, Madam Chair, and thank you, Senator. And I know this has gotten to be an issue in some areas. Glad to see it hasn't hit hard in Virginia, but appreciate that we need to kind of be thinking through the potential ramifications. And so I guess the first one was just making sure I understood that we're talking about purchasing and renting. We're not talking about buying and flipping, correct? Or are we talking about either or? In which case that might get a little more complicated if you're talking about just buying and flipping.
It's focused on what type of entity is doing that. So if it is a partnership, corporation, or a real estate investment trust that manages funds pooled from investors and has $50 million or more in net value or assets during any taxable year, then that is an entity under this bill who would not be able to go and purchase up single-family homes to do anything with, whether it be resale or to turn a single-family home into a rental.
Madam Chair?
Please go ahead.
I guess following up on that, because in one of your exceptions, it says an organization primarily engaged in the rehabilitation of single-family homes. And so maybe it's the primarily engaged, right? Because that would seem to be a pretty big exception if you do have a corporation that's out there, and again, buying them for the purpose of rehabilitating and flipping. So anyways, just trying to think of the mechanics there in terms of whether your exception really does what you intend it to do.
That's Madam Chair, Delegate Bolova, that's a question I had not thought of. Perhaps there could be some wordsmithing there. The way that this plays out, practically speaking, though, is these investment firms will come in, they'll buy up a tranche of single-family homes, and then they'll do one of two things. They'll either just keep them off the market, and they've got all the data and computers and AI to be able to figure out when's the right time we should throw this thing back onto the market to maximize our return, or take them off the market, off the resale market, and put them into rentals so that folks can't purchase the home. And it's really the resale that is the primary issue, but from my position, turning them into rentals, I think, is also something that we don't want these folks doing. But when they do the resale, as of this past March, they're getting a 55% return in profit. That's an average of about $175,000 in profit from the time that they buy these things, and they've got tons of money. They can hold them for a while and put them back on the market when it's most optimal from a profit perspective. That's really what we're going after. We're not going after the investors that are buying up and rehabbing, blighted properties.
Okay. And so I guess last question, and this is more esoteric or constitutional, right? So the focus of this section of the code deals with foreign entities, and I remember that debate. I don't know if I recall that we've ever said that an American-owned business or business entity, regardless how large, wouldn't be allowed to own American property. And so I'm just wondering if how much new ground are we breaking here, and are there constitutional implications by saying that if you are lawfully organized and you want to buy property in Virginia or anywhere else, whether you start to run into issues?
I thought about that as well, and I was a little surprised when I got it back from DLS that it was in this part of the code. I don't know that it necessarily has to be, but I think to your larger constitutional question, I mean, we do tell people when they can and can't buy something. We tell 18 and 19-year-olds they can't buy nicotine products. We tell 20-year-olds they can't buy alcohol, and so I think that there's there are plenty of instances where we as a legislative body, for public policy purposes, make a value judgment that, in order to protect these people, we're not going to allow this other group to do something.
Thank you.
Thank you, Delegate Bulova. I had the same question as to where this particular legislation was being placed in the code, and I think that is something that you might want to address as you continue to work on the legislation. I'm curious too, I know I had looked at this issue last year as well as the year before, and the research and the responses to my questions had been that this is not really happening in Virginia, and I think you shared that initially as well. And so I think my question is, are we addressing an issue and creating some possible barriers that might impede certain progress on issues when there's not this concern in Virginia as it is in other states?
Thank you, Madam Chair. And just to briefly respond, there are certainly states where there are higher rates of this type of activity going on. In California, in certain locations, it's 20% of the homes are being bought up by investment properties. But when you're talking about 11.1% in Virginia Beach and 8.7% in the DC metro area, it is still a lot of homes. So, for example, the Redfin provides the total value of the sales. So that 11.1% in Virginia Beach is $218 million. So you could probably do the math and figure out how many houses that is, but I think it's a sizable number. Same thing in DC Metro, that 8.7% of houses being bought by the investors that would be covered by this bill is $899 million, so just under $1 billion. I think to your point, Madam Chair, it's not something that is at the point where it is being abused or used like it is in other places. It is still being done here. And as housing markets get tapped out by investors in other areas, I think we want to have something like this in place so that we don't then become the next target, is sort of the forward-looking focus.
Thank you, Senator. Yes, Commissioner Dobbs.
Thank you, Chairwoman. I appreciate you taking a close look at this issue as something we've been concerned about at home. We did a data poll looking at sales in Chesterfield and Richmond between October 1st, 2022, and since September 30th, 2023, so only looking at 1 year of sales. But in Chesterfield, there were 9% of those sales were for investors and 5% in Richmond. Those numbers might seem low, but if you look at the census block groups where the sales are happening, there's huge racial disparities. So in Richmond, about 69% of those sales were in Black and Latino neighborhoods. So even if the General Assembly is not ready to take on this huge issue, I still think it's worth thinking about measures to track this. So we're keeping an eye on it, making sure that we're not seeing those type of racial disparities in the neighborhoods that these investment companies are targeting, buying up homes and then just turning it into rental property and depriving people of affordable homeownership.
Madam Chair, and thank you, Ms. Dobbs. And you said 9% in Chesterfield in the past year. So I think that is a sizable chunk. When you're talking about almost 10% of the single-family homes being bought up by institutional investors, and as you note, it's in certain targeted areas. And as the data I mentioned, it's literally the median value they're buying up is the affordable price point. So it just makes it harder on everybody else.
Madam Chair, just one question. I know you mentioned that, of course, we know other states are feeling this a lot more acutely, and the intent is to get in front of that. As you were kind of thinking about this legislation and as a potential strategy, just any thoughts about what other states that may not necessarily have this issue just yet are doing, what strategies they put into place? Do they look similar to this in order to kind of be proactive?
Madam Chair, Ms. Johnson, the research that I have done so far, which has not, to your question, been super detailed in what other states are doing, but as I've done my own research for this presentation and for last year, other states have been looking at legislation like this, and again, at a 10,000-foot level, it's banning hedge funds or private equity firms from buying single-family homes. I'm not aware that any have actually passed in any other states yet. And as I mentioned, the idea, where I got this idea was federal legislation that was proposed, I think, 2022 or 2023, and it just sort of sat and hasn't advanced for probably a lot of reasons. But we may be on the cutting edge here in Virginia in terms of being able to get something actually done on this issue.
Are there any other questions? Yes, please go ahead.
I'm curious, and maybe we just don't have the whole bill here, but what's the enforcement behind this? And what happens if one slips by? Because I'm not sure if it's the settlement agent that's supposed to enforce this, or what the punishment is if this happens title-wise in the chain. What happens to the property? Who owns it?
Yeah, I think the previous bill that I brought last year had that whole mechanism in there as to who could bring a cause of action being referred to the Attorney General, and the effort of advancing the policy and having something on the books that says in black and white that these particular firms cannot buy these particular properties. I took all that out. That may be an opportunity for another bill down the road, but this bill seeks to I think, clearly but simply set the policy of the Commonwealth that these particular transactions are not going to be permitted.
Follow-up question? Okay, thank you. Are there any other questions or comments?
Madam Chair.
Yes, please
I'll
go
just
ahead.
say to Delegate Bulova's point about the plowing new ground and the constitutional implications and prohibiting an American from buying American property. I think it's important where we're getting some of this data from. Wall Street Journal published an article that like set everybody on fire, saying 40% of home sales were institutional buyers. And John Burns debunked that pretty quickly. I mean, I think the number now was 30% of the market share, with the vast majority of being those investors that own 1 to 9 properties. Last year, it was like 0.2% in the third quarter. So like before we make kind of drastic changes, I think maybe having some of those professional data, real estate data analytic firms look at the severity of the, and Glover's point, where it's happening would be probably more prudent than kind of taking a giant step forward and just outright prohibiting some of these purchases.
Madam Chair, I think to Mr. Clark's point, we set the bar fairly high in this bill that they had to have $50 million in assets under management. And so this is not going to be targeting your mom and pop smaller investor who's buying investment properties out of their 401k or whatever. This is, and that's why we did, that's specifically why we did this, is to avoid those sort of situations where you have people who are interested in investing in real estate, but they are not professionals and don't operate a large investment fund. And so those people would be carved out or not subject to this legislation.
Any additional questions? Is there any motion as to whether or not we recommend to the full Housing Commission?
Madam Chair.
Delegate Bulova.
I guess, Madam Chair, at this point, I guess I don't know that I'm comfortable enough, notwithstanding that I think this is an issue that deserves to be explored further, that at least at this point, I'm comfortable recommending to the full Housing Commission that we endorse it. I think there were a couple of really important questions that were asked. I think Aaron's one about enforcement and, what are the ramifications if it slips through the cracks, with respect to title in the future, things to think through. I think the suggestion that we do some additional tracking is a really important one. I know you set the bar really high in terms of, who would be prohibited. I don't know to what degree those are the preponderance of the investors that we see out there, right? So the 9% or 10%, are they smaller? Are they larger? So I don't have a sense of at this point what even the impact of doing this, given some of the ramifications in terms of telling an American company that they can't buy property. So that's not to say that I don't encourage you to continue looking at that, and perhaps there's a way to integrate into future meetings a way to track the information to see if it's getting worse. I don't know that I would be prepared to endorse this particular approach at this particular time, though, Madam Chair.
So your motion, Delegate, is to not recommend endorsing to the full Housing Commission?
I guess if you want to put it more succinct than I just said, sure.
We have a motion to not recommend endorsing when we meet in December in the full Housing Commission. Is there a second to that?
I'll second.
It's been moved and seconded. Any discussion or comments from work group members on the motion that's on the floor? Seeing none, all in favor of the motion to not recommend to the full Housing Commission, please say aye.
Aye.
Any opposition? Any abstentions? And we will take this up in the full Housing Commission again. Thank you, Senator. Okay, we are now moving to real property tax assessments for affordable housing, and we'll hear from Virginia Housing Alliance from Isabel McLean.
Good afternoon, workgroup members. I appreciate the opportunity to share an update on House Bill 1446 today. This one pertains to property tax assessments of affordable housing. Since the workgroup first discussed this bill in September, Virginia Housing Alliance has worked with our members, partners, and subject matter experts to greatly simplify our proposed approach to this issue and get more data about the incidence and impact of inaccurate tax assessments. We settled on a new draft after a lot of work that preserves as much as possible the current code as was recommended by this work group, focusing only on VHA's bottom line goals that we shared with you all in September, which were to communicate clearly that the income approach is the only way to accurately assess affordable housing and to add a mechanism of accountability to this part of the code. We shared this updated draft with representatives from VACO and VML, as well as Commissioner Timberlake, who is in the room with us here today. And we were able to have a really productive conversation, but we have not yet reached consensus. There are still a few remaining concerns, specifically a concern about requiring only one approach be used for tax assessments. And we will need to consult some USPAP advisory opinions to figure out next steps there to ensure that we are checking all the boxes there and figure out the best way to move forward with that wording. And there continue to be concerns regarding the accountability mechanism that we do have in the bill. We have continued to set up a mechanism that would make localities liable for attorney's fees for an appeal if the owner of affordable housing prevails in the appeal and the assessor did not follow this section of the code. We do need to continue to work through that. We'll continue to wrestle with that. And I will say that VHA hopes that we can find a way to add this teeth while excluding situations in which a property owner did not provide their income data upon request from the assessors, just recognizing that the reality and limitations there. So in summary, we have made some progress, but we have not yet reached consensus. There are still remaining concerns, specifically about this proposed legislative solution to the issue before us. There is more work to be done, and thus we don't have a draft to show you all for review at this point since we haven't reached that consensus. But I will add that at the same time, we have continued conversations about a potential training solution to this issue where there are not any disagreements there. Joe may be able to add some more detail to this, but the Department of Taxation has started developing a training module on assessments of affordable housing. And they have met with representatives from VACO and have been connected with us so that we can contribute to that process and stay updated as it continues to develop. So I don't know if there's any questions that you all have for me.
Thank you. And yes, just to the workgroup members, I think we were all looking for copies in our packet, and we don't have a draft yet. But I will open up the floor to anyone who might have questions or comments. Yes, please go ahead.
Madam Chair, Isabel, from our work on this last year, my understanding of the locality's concern was primarily the challenge in obtaining the information about which properties were designated or were low-income properties. Isn't that easy, possibly, potentially an easy solution to that being that just requiring the developers, my members, whoever, to submit that by a date certain? And so I guess a two-part question. Was that the primary concern of the localities and the assessors? Or were there other kind of smaller details? I just remember that being the real big sticking point.
You're correct. That is one of the big concerns that we've come across. Technically, in our current code, there are mechanisms for assessors to require income and expense data, and there is a section of the code that says that data has to be required for an appeal, if that's going to be used in an appeal. But we are running up against how to ensure that that's available from the beginning if we are going to add this accountability piece with attorney's fees. We don't want there to be situations where that's costing the locality when the income data was not provided until like the 11th hour. But so I will say there are some current mechanisms already. There's just questions of how can we do this in a way that's not necessarily totally changing the responsibility onto the providers for this, since it is technically the responsibility of the assessors to get the information they need for these, but still recognize that that data is necessary, and are there things that we can do with affordable housing providers to ensure that happens. So there may be a legislative solution, but we're still working through that.
Please remember to turn on your mic. It went off.
Red and green, get confused. From conversations with my multifamily members who do LIHTC projects, the idea of setting a date certain where they had to submit that information and then losing their rights, so to speak, which potentially could cost millions. I mean, the impact and the increase in the assessment, that was a trade-off they were willing to consider. So I just throw that out there as conversations to consider, move forward to, that may be an easy way to address some of the assessors' concerns.
Madam Chair, thank you, Mr. Clark. I think that is a good idea and something that we're trying to talk through. We also asked some of our members about this, and they were open to finding a solution there too, just wanting to make sure that there is a very consistent understanding of what it actually is being asked, because, you know, the way people submit their income and expense data can be different based on where that is in the state, and so trying to figure out a way to ensure how we prove that that was done and how that was done in a timely manner. So we will continue to work through that, but appreciate your suggestion there.
Please go ahead.
Madam Chair, so I would like to say that, well, excited to hear that there is progress being made. One thing you mentioned that I think will go a long way is the training module approach. So I think that the education piece on the, for the jurisdictions and the developer communities about exactly how this would kind of manifest and what the expectations will be is something that is going to be necessary in the long term. Because oftentimes with our partners, we find that even if there is some willingness to think a little bit differently about how to value low-income properties, there isn't a lot of consistency around what that should look like, how to do it, who's responsible for what. So, I'm just happy to hear that there is some progress being made.
Madam Chair, Ms. Johnson, thank you. We are trying to come at this from multiple different solutions, and no matter what, I think training will be necessary. We do still feel strongly at Virginia Housing Alliance that a legislative solution is necessary too, but are working to, like I said, collaborate on a training solution too, and that is in the works.
Are there any other comments or questions? Since we don't have language in front of us, I don't think we can take a vote on making any recommendations to the Full Housing Commission, but we will have opportunity for the Full Housing Commission to hear it, hopefully with the draft in hand at that point.
We were deciding there was no consensus. I was going to let a lie.
Okay. Do you want to make a motion on that then?
So, Madam Chair, I think what was decided is the groups met several times and tried to come to some consensus. And what I said to Isabel is she could describe what happened so people could hear about it as something that could happen in the future, and we could look at it again. But it was not a 2025 session initiative from the Virginia Housing Commission.
Thank you. Okay, thank you very much for sharing.
Thank you for your time.
And moving along in the agenda, we are going to go ahead and under item 7, take up item 7C, that is disclosure specifically related to flyover zones with Mr. David Alba.
Hello, Dave Albo, representing Metropolitan Washington Airports Authority, along with Patrick Cushing and Michael Cooper, who is actually employed at MWA, is here also. I'm the designated hitter on this bill. I want to go briefly some background so we're all level set of what we're talking about. And what this is about is what the Virginia Code should require that homeowners know about a home or apartment they're about to purchase near an airport. When I tell all my friends about this bill, they all laugh, go, oh, duh, just look at a map. And I said, well, it's not quite that easy because it's not evident exactly how much noise or what the noise will be in the future. So look at Dulles Airport. Dulles Airport, when I grew up, was just built in the 60s. It was in the middle of nowhere, all farms, and now it's right in the middle of suburbia and it goes everywhere, all the way out to Loudon, all the way out 66. It was designed to be in the farms where there were no houses, and the world changed, okay? Now, when you go out to Dulles, they are currently operating at half design capacity. So Dulles was built to expand. So if you bought a house near Dulles, you wouldn't know what it's going to be like in 20 years. Also, there's a 5th runway that's about to be built. I say about, maybe next 15 years. I went out there and stood in the area where the 5th runway would land and take off, and not a single plane flew over my head. And a person who would buy a house in the future there might find that in 20 or 30 years, they've got 757s flying over their head. They never knew about it. So Loudoun County created a affirmative disclosure to tell buyers when they bought a house if it was in the Dulles Airport noise zone. You've all had briefings on how that's been created, but they go out there, use science and stuff, and then create a map, and they find out what the average noise is going to be in different areas. Fast forward to this last session, House Bill 467, Delegate Simon, and Senator Locke's 354 was passed, and that bill said that all affirmative disclosures have to be in the Virginia Code, and local governments can't make their own. And I can make their argument for them because it's a good one. It's really hard for people, especially realtors, to know 140 different rules throughout Virginia. So they wanted to have everything in the Virginia Code. Metropolitan Washington Airports Authority asked that if we could get the Loudoun County ordinance put in the Virginia Code. And we lost the day, and we're not able to do that. Instead, it was sent here for study. So that gets you up to today. What have we been doing? Well, I went and met with realtors, met with Aaron and Mary, who's here, and some others, heard their side of the story and why they don't want affirmative disclosures. They said they prefer a passive disclosure. So let me get back step. There's 2 ways you can let the Virginia Code lets homeowners know about things about their property. One's called an affirmative disclosure. When you go to closing, if the house had been used to cook meth, or if the house had building code violations, they have to sign a piece of paper that says, heads up, I know that this house has a zoning or building code violation. That's called an affirmative disclosure. That's what we wanted. We being Dulles Airport and National Airport wanted an affirmative disclosure. The other one are passive disclosures. There are 17 passive disclosures. These disclosures say, they typically start off, seller makes no warranties as to whether this house is in a flood zone, but you need to use your own due diligence to go find out. Okay, so most of the realtors who didn't want affirmative disclosures had a good point. There was like, when does it end? It's like a Christmas tree. All you legislators know what the Christmas tree is, but we use that as an analogy. You're putting another ornament on the tree. Next is going to be, heads up, you might have a pig farm next to you. Heads up, you might have something else. And they also pointed out that Virginia's tradition is a buyer beware state. They said, we don't have a problem with the passive disclosure. My team said, passive disclosure is not enough because all it says is we make no warranties about whether or not you're in a noise zone. And how the heck could a buyer know where to go to get a noise zone map? What we're afraid of is the following. Dulles Airport is a major economic engine. 50.6 million passengers a day. It employs 28,000 people, has a $23.6 billion impact on the economy. It is a major cargo hub. You don't see it because most of us are asleep, but there are giant planes flying out there all the time delivering cargo. What we're afraid is going to happen is what happened at National Airport. In the 90s, when I was a delegate, I represented the southern tip of Fairfax County, which included Mount Vernon and Lorton. And there are certain times of the day when the wind went a certain way, planes landing and taking off would go over Mount Vernon and Lorton. And my constituents called me, and I said, well, you know, profiles of courage, call your congressman, not my issue. But what they were saying is, I can't go to sleep, I hate this noise. And I would say, yeah, but it's been there since 1940s. I mean, come on. It's been there since 1940s, and it's 1990 now you're complaining? Well, guess what? They eventually complained enough, and Congress and the FAA submitted restrictions on National Airport. So National Airport now has limited flights in the evenings. What we're afraid of is this same thing happening in the future. We need something that when in the future, when someone complains, because someone will, that we can say, when you bought the house, someone told you that you were in a noise zone. So we kind of came at an impasse, but then my group met, and I don't know whose idea this was. If you like it, it was mine. What about creating a website where a prospective buyer could easily go and see what the noise zones are? Michael, with his team at Dulles, said, yeah, we actually have one of those things. It looks like you're on Zillow or something. You type in your address, it shows you where you are, and it shows what the average noise from aircraft is in that area. So then we met with the Department of Aviation. Department of Aviation, do you think you could come up with a website that would have airports that have noise zone maps? They have to be FAA approved. It's not some guy with a crayon creating a map. It's an FAA approved, or it's done in a way that FAA mandates it's done. See, Aaron, I saw you caught me on that one before. And the Department of Aviation said, yeah, we can do that. In fact, we can do it with existing resources. We don't even need a budget amendment. And so then I went back to the realtors and said, here's our idea. Let's do buyer beware for all the reasons that you stated, but have buyer beware plus a website so that the purchaser can log on to the website and can see whether their house is in a noise zone. And I think it's a really good compromise. The bill you have, and I don't have to walk you through it unless you want me to, but basically it says that the owner makes no representations with respect to a property's proximity to a public use airport, blah, 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 blah. There shall be a website that has a map that meets Federal Aviation Administration noise criteria, shows the day-night average of sound levels, and may be provided by either by the public use airport or a locality. So there's no mandate that someone has to have a map, but if a locality has approved map or an airport has approved map, they send it to the Department of Aviation. Department of Aviation puts it on their website. The idea would be that on the form, at closing, it would have the Department of Aviation's website that would tell them, we make no representations about whether you're going to buy a house near an airport, but here is access to how you would find out. And then, of course, it has to have language giving the Department of Aviation the authority to do this. So this is not what my client wanted, but I think it solves a problem, because I think that we'll be able to, in 20 years, when someone complains, we can say to the FAA, if they bought their house after 2025, at closing, they were given access to a website, and they could have looked it up for themselves. And I don't know what else we can do. And we believe that that would be a salient argument that would keep the FAA from imposing restrictions in the future. So that's what he got.
Well, thank you very much for that presentation, and I'll open up the floor to questions or comments from our work group members. Delegate Bulova.
Thank you, Madam Chair. And I do want to thank all the stakeholders very, very much for working this out. I think it is a nice compromise. I also want to thank you for applying this to all airports. I know that particular one that brought this issue to the table was Dulles, but all airports have the potential to be noisy, and you just have to take a look at Manassas and Leesburg and others where you've had suburbia sprout up around them, and so I know they're kind of going through the same issues. The only one small little thing that I wanted to ask about is there's a line in here saying provide the purchaser an active internet link to the Department of Aviation's website if one exists, where maps could be accessed. But given that enactment clause number 2 mandates that they have that website, I'm just wondering if we could dispense with if one exists, since
I think if one exists was supposed to refer to whether the airport had a noise map or not. But you bring up a point that probably could be tightened up, because when you're reading it, you're thinking if one exists, meaning the Department of Aviation's website.
Yeah.
So, okay, I can work on that.
Okay.
There's another issue that Ms. Corman brought up in our conversations was that we want to make sure that if an airport doesn't have a map, that someone going to closing and assuming that there is no map means they're not in an airport noise zone. You might have a smaller airport that doesn't have enough money to do an FAA type study. So we're going to work on some language to make sure we clear that up. So this is almost a final product, but we'll try to fix that problem too.
very small. Thank you.
Other questions or comments? Yes, please go ahead, Ms. Corman.
Yes, Erin Corman with the Realtors. We want to thank former Delegate Albo for working with us and meeting with us. Our members have not blessed this language at the current time, and I think I've expressed with Mr. Albo that I think there is still some tweaking with the language that can and probably needs to occur just to align it with the rest of the statute. To clarify that that the website is just one option for a buyer to go to. And I feel like there's going to be something from Legislative Services about putting an actual internet link in the code, but I promised I would look into that. So just to clarify, we are still working, but there is still work to be done on the final language. Our members haven't blessed this at the current time.
Thank you. Yes, please go ahead. Senator Locke.
How is this, Madam Chair, and how is this different from the military basis language?
Good question. We know that Realtors and you didn't like that, so we didn't put it in there.
Because I live near.
Yes, right. Well, the military one is an affirmative one. So that's one of those that if you buy a house near the military airport, you get an affirmative disclosure that says, heads up, you are buying a house near an airport. This goes into the other type, the passive disclosure that says, we make no representations about whether or not you're in an airport, but you need to investigate yourself, and to help you out, here's a website that would make it easy for you to research it.
I love jet.
You like jet noise? So you're the National Association of People Who Like Jet Noise. I know when I go to Virginia Beach, it's nice.
I have one concern, and that is with the website. There's a presumption that everybody would have access to the technology and be able to look at a website and be able to make these determinations. But as we know, there's a tremendous digital divide, and it continues to create levels of inequity in terms of access to necessary information, access to rights, especially for individuals who may be purchasing property for the first time. How would we address that issue of inequity and lack of access for individuals who may not be able to get to a website?
Well, you've already done that because you have about $1 billion of federal money, not to mention the money that the General Assembly budgeted for Virginia Technology Initiative. And it's underway. We're expecting it's called BEAD, the BEAD money to be distributed. And the goal is to have every single home and apartment in Virginia with access to internet. And that has been a very, very expensive and long-term project. In fact, you all it's all happened after I left, but you all have budgeted tons of money for that. Second thing would be, I would assume that if a person has enough money to be able to buy a house or an apartment, that they would be able to get to a library. Maybe in rural Virginia, access to libraries might not be as robust as in other areas, but I would assume that they could go to library and log on.
Any other questions or comments? Okay, is there a motion to make a recommendation to next month's Housing Commission?
Madam Chair.
Delegate Bulova.
Realizing that there's some small tweaks and things happen between now and the Housing Commission, it's ultimately the Housing Commission that gets to decide, I would move that we recommend adoption to the full Housing Commission.
Second.
It's been moved and seconded that we recommend adoption to the full Housing Commission. Is there any further discussion? Seeing none, all in favor, please say aye.
Aye.
Any opposition? Any abstention? One abstention.
Right,
Thank you. Thank you for your presentation. Okay, next we're going to take up our discussions around affordable housing on religious property, and we have 3 possible legislative items under that particular topic, as well as a budget proposal, and so we will take up the 3 recommended items of legislation, and we need to pass out 2 of those items as well.
Only one of them has been the Housing Commission
Yes.
legislation.
So if we can pass out the 2 proposals that are in front of us as well, we will start first from the work group that was part of the Housing Commission, and I think Commissioner Lurch, you were going to present on that.
Madam Chair, yeah, I think it was going to be me and Ms. Dobbs. And do you want us to do it from where we're sitting, or do you want us to go up to the podium?
I'm perfectly fine if you do it where you're sitting,
Okay.
or if you'd like to go up, you're welcome to do that as well.
Well, Elizabeth has motioned me to go up, so I better do what she says.
And if you could give a little bit of background about the work group and who was part of that conversation, that would be helpful.
So, Madam Chair, members of the work group, so Joe Lurch with VACO and Laura, who was also on the work group, and I believe we had Virginia Housing on the work group help us, and I'm blanking on the gentleman's name. Jamie Bodmer, thank you. And I think, Andrew, you were on the work group, were you not as well? Somewhat, he would call in. We would get this disembodied voice asking questions. So just a little bit about, the background on this from the bill from last year. For full disclosure, that VACO opposed because it was creating a by right for residential use for religious-owned property, and we, I won't go into all the concerns that we had, but what the work group settled on was looking at tightening down what we meant by religious property and affordable housing, and those are kind of the definitions in that section there. And persons of low income, what is a religious organization? And then it was then to kind of spell out kind of how this would fit in with localities, plans and ordinances. And at least from the VACO perspective, and VML can chime in as well, or for cities, the key for us was that paragraph D, regardless of how you define this, was giving that flexibility to a locality to say, how would you allow this within your community, and given all the things. And we tried to make this, the way we worded it was to say, permitted through any combination of zoning district regulations, including but not limited to, which I think is important because you can be creative, permitted uses within a designated overlay district, such as a water and sewer service district, the idea of getting density in certain areas. Or within an urban development district, that was established several years ago in code, or as a special exception. So with that, the idea here is that you define what it is, you work with religious organizations to see how it may fit within your code, to permit this use. And I will say, from our members' perspective, we do understand there's a lot of this property that sits unused or underutilized. And so there's an opportunity here for creating affordable housing or other uses within a community that a community might want. I'll note that over this past summer, the Coalition for High Growth Communities, they had a presentation from somebody that works in this sphere nationally that was advising various religious organizations about how you go through the process. And I think that may be some of the other work on the budget amendments. So I don't know if, Laura, you wanted to add anything.
Sure, Laura Dobbs with Homer, Virginia. I'll just add that we started with the language that was sent to the commission, the bill language that was introduced last year. One of the other pieces is moving the part of the code that it sits in, so moving out of Title 36 into 15.2, which concerns localities' land use authority. And we had some discussion about whether to expand it to other types of tax exempt nonprofits, and ultimately just kept it to the scope as presented to the work group. And there was also some discussion around how we defined affordability, and we ended up sticking with how it's already defined in that part of the code that gives a lot of leeway and flexibility to localities of how they're defining affordable housing. But there is a little bit of unresolved tension about what is the best pathway for faith-based organizations to both meet their mission and also address some of the barriers that they've faced when trying to use their underutilized land to build affordable housing. We know of at least 30 faith-based organizations that have tried to build affordable housing on their property, but only about half of those have actually succeeded in getting through that process. And we've been trying to identify what are those barriers. Is it the rezone, or is it the other building processes and permitting that those projects have to go through? And as Joe Lurch mentioned, there's a lot of this land in Virginia. There's about 74,000 acres, which is, if you're trying to imagine how much land that is, about that's twice the size of Richmond. So we have a lot of land available that we could be building affordable housing on. And if we are able to find a pathway to do that, that takes out one of the largest cost of building affordable housing, which is the cost of the land. So, separately, I think we've all had conversations with faith-based organizations that have been through this process, that have articulated some of those barriers. And so I hope that we can all work together to find a solution where I think we really need guidance from the state for localities of setting a floor of doing this, while also appreciating the concerns the localities have about a one-size-fits-all solution.
Thank you to both of you for the presentation. And just as a further background, as a reminder that I and Delegate Carr carried the initial legislation last year, and that's why it is in front of the Housing Commission. It was a recommendation out of the committee that the Housing Commission examine this. And so I apologize. I know we might have confused people. This bill, this proposed language was in the packet that you had in front of you, and it's Senate Bill number XX. Is the legislation that Joe and Laura were just talking about. And this is what was tasked to this work group over the last few months, and I appreciate the hard work and the language that has come. So this is the version from the Housing Commission, basically, that's been presented to us. I would like to not take any action or votes right now until we review the other two options that are here, but certainly want to open up the floor for any conversation or any questions that any members may have for Senate Bill number XX, which was just discussed now. Delegate Bulova.
Yeah, thank you, Madam Chair. And I guess just broadly, and I think this applies to all three of the bills out here, I still have a general level of discomfort making specific reference to religious properties or faith-based properties. I don't have as much of an issue if we're talking broadly about nonprofits. But I think hearkening back on some of the earlier conversations we have in terms of providing a special benefit or consideration to a religious organization, I think there were some constitutionality issues along with that. And quite honestly, if you're a nonprofit, not religiously affiliated, and you're sitting on a lot of excess land, I would want to think that we would reference it broadly. I guess the question that I have, Madam Chair, is down there at 15.2 and then that A, in terms of what that is actually doing. Because I think my primary other concern is making sure that we're not overriding local zoning authority. I don't think these things work very well if you don't have the community involved, and it's by right that you have that much latitude with respect to what you would be putting on a property. And the way I read that first area is that it still would override your general plan or your zoning ordinance or any regulations, right? And so notwithstanding any of those, at the request of a religious organization, a housing development may be constructed. And so the way that I read that is it doesn't matter what your local zoning ordinance or subdivision ordinance or comp plan says, that's a by right for your religious organization. And I just want to make sure that you are reading it that same way, because to me that would be very, very broad without particular parameters.
Yes, Madam Chair, Delegate Bulova, it's funny you mention that because I was rereading this again as we were sitting there, and I noticed that A somewhat contradicted D. Mm-hmm. And so I think you caught on to that. I think if you could say something like notwithstanding other than pursuant to this section of code. I honestly think probably just doing away with that notwithstanding any provision of code, because D is what, in our mind, would carry the day. In other words, a locality may, pursuant to how it develops its zoning ordinance. So I think you raise a valid point.
So, Madam Chair, if we were to jettison A and just go down to D, and that was going to be kind of my next point, is A and D tend to conflict. I guess what additional authority or powers or structure would actually come from that? Because the way I read it is that it's a housing or a locality can use all these combinations of things in order to be able to facilitate this process. And perhaps it's just a way of saying or encouraging localities to organize around that. And that's fine if that's the message we want to send. But to me, it doesn't provide any additional power or authority other than to say you can bring these things all together, well, which I think they can if they really wanted to.
So, Madam Chair, Delegate Bulova, I think it goes to your original concern, which is, just maybe expanding the broader universe of property owned by nonprofits. But it goes to a section of code that I don't have the exact citation here, but it's generally under zoning ordinances, and it was an issue that we brought up last year. And essentially, in that beginning section of code, authorizing localities to adopt zoning ordinances, and I'm going to paraphrase here, it says you have to treat similarly situated property the same. And the way we read that and our concern is you could have, say, two properties side by side, R1 district, and by virtue of last year's bill, because one was owned by a certain ownership, in that case with his organization, it would have more rights. So this was a way to maybe allow a locality in certain instances to say if it's defined as a religiously owned property and it's meeting these certain basic affordable housing parameters, locality provides some flexibility in that. Does that make sense? I know it gets a little confusing.
Madam Chair, that does make sense if the issue comes down to not looking arbitrary in terms of how you treat properties next door. I can see where that would be useful. I guess I would love to see a bill that actually says that succinctly, because that I think would help out and could be very useful, realizing that I would want it to include nonprofits of all stripes rather than just focusing on those religious institutions. But I think you might be onto something, where you're just making sure you're not caught in, a legal predicament by saying, hey, we're going to allow us to have more flexibility in terms of this property. Thank you, Madam Chair.
Thank you. And Senator Locke, you had a question.
I think Delegate Bulova addressed the issue that I had with regard to making sure that we're not undermining local government zoning authority.
We would agree with that.
My primary concern, coming out of local government. So I get it.
Thank you, Madam Mayor. Any other comments or questions? Yes, please go ahead.
Thank you, Madam Chair. Renee Pulliam, Virginia Apartment Management Association. I firmly believe that there is more need for affordable housing across the Commonwealth. I respectfully would request that when we are looking at bills that would expand the opportunities for affordable housing, that we would have the materials in advance so that we can properly review, because there are some things in here that are written in a format to me that looks almost like idea generation versus bill language and proposals. And some things that I would have liked to research in advance. So I just want to note that I am in favor of anything we can do to advance affordable housing, but it just makes it very difficult when we don't have the appropriate time to review in advance. Thank you.
Thank you, Commissioner. And I believe it was in the packet that was sent electronically to all work group members. Molly, you sent it a couple of days ago, I believe. This one was, yes, yes. So the one we're talking about was sent in that packet. And we have two versions that, yes, we are just distributing today. But the one that was just presented by Mr. Lurch and by Ms. Dobbs was in the packet that was sent out electronically. So thank you. Okay. We will circle back to this particular version, but I wanted to talk about the two other options that are on the table, and do apologize that these are being presented to you for the first time. So you did not receive these in the packet, and nor were these part of the Housing Commission work group efforts. There's been a lot of different groups that have been working on this particular item of legislation, a lot of interest in it, and so we have two other options just to consider, and because you're receiving it for the first time, it is completely understandable if you don't want to take any action or make any recommendations based on what you are going to hear today. But I will go ahead and share the bill that I will be introducing this session, and Delegate Carr is also carrying it on the House side, and this is the one that is labeled Bill Number X, and that is one of the handouts of the two that you received just a few minutes ago. And this bill is an effort to address. I'm talking about the enabling, and then you're going to talk about it. Okay, I'm sorry. My mistake. I'm going to be talking about the one that's labeled Bill Number question mark. So, yes, we are being as creative as possible today. And so, again, we've had a lot of conversations. Many different groups have been working on trying to address the questions that Delegate Bulova, you just raised, the same questions that Senator Locke was also raising, and what we heard in session last year. And this particular proposal, which Delegate Carr and I are going to be introducing, is basically enabling language for our localities. There are some localities that have been seeking this option to be able to present to faith-based communities and other nonprofits to be able to address housing needs, and to be able to grant this authority to whether it's churches or other religious entities to move in the direction of using their properties for establishing affordable housing. And this particular proposal then takes a step back from what we had last year that was giving greater authority to our religious organizations. And this one is saying, if you take a look at Section 2A, that any locality may by ordinance adopt of faith and housing program that creates an expedited or simplified zoning or approval process for religious organizations and property tax exempt nonprofits. And one of the barriers, well, what we've heard most frequently from affiliated organizations or faith-based organizations is that one of the greatest barriers that they face is the whole process of moving through the permitting process of zoning and getting the approvals. And so localities by this particular measure would have the option to create a streamlined or simplified opportunity for people to apply, organizations to apply, and to expedite the rezoning. So this is a permissive bill that allows or enables localities to make that decision, should it be something that they want to do in their area. And it is a little bit different than from the bill that was introduced last year. So this, again, is enabling language for localities, but doesn't mandate that they approve or rezone for the purposes of faith-based housing. Any questions or comments on this? Yes, please go ahead.
Thank you, Madam Chair. I only attended one of the small groups. I'm curious because the meeting I attended, there were some feelings and concerns similar to Delegate Bulova's about the use of faith and religion in here. Our fair housing statute is incredibly strict with respect to that, to the point that, you can't put a religious symbol on your business card, even though it means, nothing to anybody else or who you will or will not work with. So I know that was brought up at one of the meetings that I went to. Was there any further research on that and as to why we can't just refer to a certain category of nonprofit and leave the words religion and faith out of it? It concerns me about, the Attorney General's office and where this will go.
I share some of those concerns, and I think that is an area that we need to continue to work on before the bill is finalized and the language is presented in session. So I certainly agree and have similar concerns. I don't know if, Sheila, do you wanted to address any of that in the conversations you've been having with stakeholders?
Happy to speak briefly. Hello, Sheila Hurley-Hennessy with the Virginia Interfaith Center for Public Policy. Thank you for giving me a moment. I think that from a tax and legal perspective, saying property tax exempt nonprofits does explicitly include all congregations and faith communities. I think as we've been talking to people, it's clearer public messaging to talk about faith communities and then follow up by saying, but not exclusively faith communities. We're not trying to create a new tax law. I think that that's definitely an amendment we would feel okay with. If you did not want to put the word faith into code here, understood. But that's sort of where it came from, was messaging and clarity.
Thank you. Any other questions or comments, Delegate Bulova?
Yeah, thank you, Madam Chair. And I guess building on with Aaron's comment, if we can make it more generalized, I think that would make me feel more comfortable. The one I had just some comments on was 2 and then B, so the locality that adopts an ordinance pursuant to this section, and then it gives a couple of different things that I think would be very helpful. Two that I just might have a little concern about is Little Romanet 3, the guaranteeing a fair review by zoning commission and local government within 3 months. I just want to make sure we define what that is. And so if we're talking about a fair initial review and getting it before somebody, whether that's a zoning commission or a planning commission, I think that's fair, right? I don't know that I would feel very comfortable unless it was caveated. I think the idea here is that you want a first reaction from a planning body, not to have some kind of final review within 3 months, because I don't think that would be serving anybody's interests. And then the same thing with little 4 there in terms of, I don't know that I have so much trouble with the fees, but the timeline, I think that could cut off some very valuable public discussion. Those timelines are very purposeful with respect to making sure that everybody has time to review stormwater impacts on transportation. So anyways, okay with if somebody wants to reduce the fees, but I guess I would caution against reducing by half the amount of time associated with the rezoning process, because I think those are well thought out in terms of how you engage the public in the larger discussion.
Thank you. Any other comments or recommendations?
So I have a question about the zoning overlay district. If the,
Can you turn on your mic?
if the religious organization, Madam Chair, already owns the property, why do they need an overlay district? And what would that overlay district be? Would they draw it afterwards, just over that particular religious organization, or put it over the nonprofit and it would exclude, they would have extra density, but nobody else would? And it would be drawn afterwards?
It's not my understanding that it would be drawn afterwards. It would be on the land that's already owned by those religious organizations.
So all land that's owned by religious organizations would be part of an overlay district, Madam Chair?
I'll ask Sheila to address what they were working on in that stakeholder group.
Absolutely. So the short answer is this is a menu of options that localities can consider. We are not saying that every piece of land owned by a faith community would automatically be part of an overlay district. However, some localities who have built affordable housing on faith-owned land have done so using an overlay district, which requires a rezoning process similar to a special use permit, and therefore we wanted to explicitly state that as one of the options a locality could consider. For example, this block where 80% of land is owned by a faith community, I'm thinking of Tabernacle Baptist Church in Petersburg, which has built affordable housing, has this increased usage. A locality could say something like that.
Senator Locke.
And I'm just asking these questions as somebody coming out of a local government background. And where it says a locality that adopts an ordinance pursuant to this section, and I got a problem with the word shall.
Okay.
And it goes into all of these different things that this ordinance shall do, correct?
I have it open on my computer, but I confess
Okay.
I don't have the text in front of me.
But it's waiving rezoning fees, and when you start saying that this is what the locality is going to do, what's to stop any other entity from coming to a locality and asking, if you waived it for them, you need to waive it for me? And making guarantees, I mean, if you're saying guaranteeing a fair review by zoning commission and local government within 3 months, putting these kind of restrictive guidelines on overworked zoning boards, reduced by at least half fees and timeline associated with rezoning for religious organizations or property tax exempt nonprofits. I mean, why these type of restrictions for these particular, and I want affordable housing too, but why are these type of restrictions being put for this when zoning boards are already trying to work under very tight timelines for everybody else?
Madam Chair, I'm happy to take a stab at that, but happy to defer as well. Okay. So the intention of that paragraph is actually shall create a process to expedite the rezoning. The expediting ordinance can include but is not limited to. So if you're adopting an ordinance, that ordinance shall expedite the rezoning. Some ideas for how to expedite that rezoning are all those Romanettes. So in answer to your question, it is not mandating that a locality that adopt this ordinance do all of these things or any of these specific items. It is opening the menu of options. That's the briefest answer to your question. The longer answer is, having been in a heck of a lot of those local zoning conversations, you're absolutely right. Multiple other developers will come and ask for the same fee waiver, but that is a choice that the locality gets to make. The goal of this is for a locality who passes such an ordinance to make life easier for the Planning Commission, for the City Council, for whomever, by streamlining said process. But totally understand, the shall only applies to expediting the rezoning, not each of the suggested steps. Or, yeah, considered steps.
Senator Locke.
Madam Chair, when you say shall, you're mandating.
Thank you, Senator Locke. And I think it just, the shall refers to that first sentence, that shall create a process to expedite. And we can play with the language because this is meant to be enabling language, granting our localities the option to create ordinance for institutions, for organizations that want to convert property that is either sitting empty, if it's built property sitting empty, or land that is currently owned by religious organizations, and provide the option to carry out a faith mission, which is to provide shelter to those who are shelterless. And so the purpose is to get the ball rolling in terms of giving options for the localities to support organizations within their own area that want to move forward. As we've seen, some places have already granted this as an option. So are there further comments or questions about this particular proposal? Yes, Mr. Lurch and Kelly.
Yeah, Madam Chair, thank you. Just a little bit of background. So we've seen versions of these that we've shared recently at our annual conference with our members to get their feedback. And so just a little bit about that. In terms of the comprehensive plan, they were opposed to a mandate that it shall be a part of a comprehensive plan. I'll just note that the comprehensive plan right now, there is a requirement to address affordable housing, and I think that's something that could be done through that process. I think also as part of a comprehensive plan process, sometimes what a locality will do is they will collect data that can help them make some policy and informed decisions. Some of that data could be the amount of land that's owned by nonprofits that is underutilized or unused that could help inform that. In terms of an ordinance, they did not want to support something that was just an option, if it's just an option. So I think in reading that 52-2293, the A part is you may adopt ordinance, but then you get into the details, and I do agree with some of the concerns raised about the shall in terms of, particularly in terms of the process and short-circuiting it. I'll note, that a lot of times land use decisions that localities make are based on process. And so I think we need to be very careful there. And I think Delegate Bulova can probably relate the ZMOD in Fairfax County was challenged on process. And they had to go back all through the process. So I'd be concerned about that. I do think, though, on the last page, I think there was some general idea and support of creating some capacity for these organizations, which, are all volunteer membership potentially, that are not familiar with the development review process. They could probably use some help, whether it's, from a developer that can have their time, an architect, an engineer. And once again, I think it comes down to, it even goes beyond just affordable housing. You have unused or unutilized land within a community. What is the community potentially, in conjunction with the owners, looking at for a highest and best use that can serve the community? And so I think that's a productive conversation.
Thank you. And Ms. Braxton Hicks?
Yes, Madam Chair. I'm Kelly Harris Braxton, Virginia First Cities Coalition. So Virginia First Cities, we represent cities, and we're extremely supportive of attempts to create additional affordable housing. It's very, very important and very, very necessary to our members and to our cities, et cetera, and that's just goes without being said almost. But we are very concerned about local authority and losing that authority to do the things that need to be done. I think one thing that has been mentioned several times, and I just wanted to echo that, is that using a more generic term, even though these religious organizations want to move forward, I think it's great. I think it's great that we can use that property that is not being used. I think Joe Lurch just said a good thing about maybe bringing additional resources to help shepherd folks along so that they're more comfortable with using whatever is available in zoning, et cetera. But we are concerned about, I'd prefer more of a generic term, the nonprofits, et cetera, as opposed to focusing strictly on religious institutions. I think I'm a lawyer myself, and I think it takes us maybe a little too far. We need to be very careful, is what I want to say.
Thank you. Thank you for those insights. Any other comments or questions? Okay. We have, yes. Okay. We have one more proposal to consider, and I'll ask Laura to present that from another group of stakeholders that has been working on these issues. And this is the handout that's labeled Bill Number X. From here. Thank you, Laura.
Thank you, Madam Chair. Laura Dobbs, Housing Opportunities Made Equal, speaking on behalf of the Commonwealth Housing Coalition, working with a coalition of folks who are pro-housing and want to help create pathways to building more housing in general, but especially affordable housing. And one of the biggest barriers we see is local zoning ordinances. About 80% of land in Virginia is zoned for single-family only, and it is a very expensive and time-consuming process to do a rezone to convert that to be able to build multifamily housing. So this version, Bill Number X, we think works in tandem with the Bill Number question mark. We see Bill Number X as setting a floor where the state is able to step in and provide some cover for localities. A lot of these projects end up falling apart because of just a few loud people at the local level that scare these faith-based organizations into pursuing these projects, oftentimes making very discriminatory statements about the type of people they envision living there, and it scares off the project altogether. I mentioned earlier we know about 30 faith-based organizations that have attempted this, but only half of those have succeeded. And so we've been looking to see what are the big barriers, and one of them is the zoning. So under this version, it would set a floor for the type of development that could go on either faith-based or faith-owned property or tax-exempt nonprofit organizations' property that is already connected to public sewage. One of the concerns we heard from localities is in more rural areas that are those infrastructure upgrades are one of the big concerns when looking at these projects. So it's focusing only on ones that are already connected to sewage and have that infrastructure. It sets out some basic requirements about the number of affordable units, the affordability period, making clear that you have to follow the non-discrimination rules defined under the Virginia Fair Housing Law, and that you can include some publicly available ground floor facilities, such as space for childcare, and has some minimums of what's allowed to be constructed up to 3 stories, or the height of the tallest existing building with a quarter mile, whichever is greater, as well as the density to make sure we're not, if you're in a single family neighborhood, you're not just building a 6-story apartment building. And the way that this would work with the version that Virginia Interfaith Center introduced is you have Bill X that sets a floor. It is the state coming in to provide guidance and some cover for localities of what's allowed. And then If localities want to do more and set a higher ceiling, they are authorized to do so through enabling legislation. And the difference between the two as well is bill number question mark has those budget amendment components, whereas Bill X is really focused on the initial zoning piece and leaves intact the other building permits that have to get done in order for these projects to go through, such as site plan reviews, making sure that it's following building code regulations, setback requirements, all those other necessary pieces are still up to the locality. And I'm happy to answer any questions.
Thank you. Thank you for the presentation. Are there any questions or comments on this particular proposal? Yes, please go ahead.
So probably no surprise here that VACO would be opposed to this, as it is a mandate. I will note, and I think the proponents of this bill, they put a lot of thought into this, and essentially what they're writing is like a provision for a zoning ordinance, but it's a zoning ordinance that would be applied statewide. And it's our contention this really needs to be done at the local level with all the stakeholders and how they figure this out in terms of providing affordable housing. And so for those reasons, we could not support it.
Thank you. And I'm hearing from our executive director that Senator Locke has indicated that she cannot support. She has to step out of the meeting. Delegate Bulova?
Yeah, I guess, Madam Chair, I'm kind of in a similar position, and I appreciate the work on this. I would note when you're using special use, if I recall, Arlington County is so dense that everything goes through a special use permit process. And so this would basically mean that places like Arlington, this would totally override their local zoning authority. And just for context, when we're talking about 4 units per lot, 20 units per acre, that's a pretty dense townhouse development if you're trying to conceptualize that would be by right on any nonprofit or religious one. And then the one that will definitely cause you trouble is the 1 parking space per unit, which will cause pandemonium. For those reasons, while I appreciate the intent, wouldn't be able to support this particular venue.
Any other comments or questions? Okay. Yes, please go ahead.
Just a quick question, in terms of process. I'm looking at some of the related budget amendments, particularly around the work to help build the capacity of some of these organizations who are interested in exploring affordable housing development. Is that an element that can kind of outside of this proposal continue to be encouraged in some way, shape, or form?
Thank you. That's a great question. And we actually have a final presentation by Delegate Bulova, who has budget amendment proposals that will help in the process with the same intent of addressing some of the barriers that impede opportunities for some organizations. So if that's your question, I will go ahead and ask Delegate Bulova to introduce the budget proposals that he is bringing before the commission.
Yeah, thank you, Madam Chair. And I think this is probably more of a FYI unless the Housing Commission or the work group wants to do something more with it. But one of the things that I do really appreciate through the conversations with the faith-based housing community, as well as all the different nonprofits, just are the really expensive upfront costs with respect to even finding out whether a project is viable. And so you're talking about the soft costs of conceptual engineering, preliminary engineering plans. You're talking about the process of going through the zoning process. And we had a very successful project in the city of Fairfax. It was Fairfax Presbyterian that did exactly this. So they had extra land. They didn't need it. They wanted to use it for affordable housing. And it was about a month ago where it was delightful that we went through the community process. It worked. And we actually broke ground on the affordable housing units. The question that I asked the pastor afterwards was, how did you afford the upfront things, to find out whether this was viable? And his answer was that they were lucky enough to have a pro bono lawyer who was able to absorb those costs. And that pro bono lawyer was nice enough to get back to me with an estimate of how much he had to spend navigating that process. This was a little bit more complicated than some others, but it was in the tune of about $100,000. And that doesn't include some of the engineering or the concept plans. And I can easily see where you have a group, whether it's faith-based or a nonprofit, that wants to do the right thing. But that's going to be a really heavy barrier to them taking even the first steps to find out if something is viable if they've got to come up with $100,000 or so. And so the language that I asked our appropriations staff to put together would be a pilot program to help support those costs and do a grant program up front. And so some key items to that is, so it would be eligible for all nonprofits, so that's faith-based or anybody who's a 501c3. DHCD would put together the guidelines, so we don't want to micromanage how they would put together a project like this in terms of grants and how those are done. One thing that I did want to mention, and this kind of gets back to the whole faith or religious aspect, is that DHCD would have to partner with another 501c3 in order to be able to get money to faith-based communities, because there's a constitutional prohibition on giving money to faith-based communities or religious organizations. So it can be done, but it does kind of demonstrate that you have to be very thoughtful. So eligibility, everyone, DHCD, the guidelines, you'd have to partner with another 501c3. And then it all comes down to making that money available, so that you've got your eligible recipients. Initial development would be defined as market studies, feasibility assessments, zoning analysis, preliminary design concepts, everything up to, but not including, construction costs. And this would be a pilot, so we would see whether there was interest, whether it was effective at doing what it wanted to do, and it has a report out back to the General Assembly in 2026, so that we could look at the findings, see if it worked well, whether it needs to be tweaked, whether there wasn't enough interest, but it would give us an idea of whether this is something that we would want to take further action on and turn it from a pilot project into a more permanent program. So that's the gist of the budget amendment. More than happy to share the exact language with members of the work group or the commission if you're interested. My intent is to push forward with it. I think it's would be a cool thing to be able to go ahead and do, but just wanted to share that with the work group for your information.
Thank you, Delegate, and that's really helpful because it complements some of the intents of the legislative proposals that we have here. Again, I think all three of the proposals are seeking to address the ways in which we might be able to reduce barriers, increase opportunities, and finally, of course, address a concern that is affecting all of our localities, and that is the lack of housing and the clear lack of affordable housing for so many folks here in Virginia. Are there any questions or comments from the presentation that Delegate Bulova has made? Yes, Director Palin.
Madam Chair, Delegate Bulova, is there a way, if the DHCD can look at giving the grants to the 501c3s or organizations that are financially, that show that they're financially needy and need the money in order to go forward and do the project? Because some of the religiously based organizations within Virginia have more money than our largest developers. Some of the very large churches, even my own church that is interested in doing affordable housing, when you're talking about the pro bono attorneys, all those members are present within the congregation. If it's something the church wants to go forward, I would think it would have to be an entity that needs that financial backing.
And Madam Chair, it's not explicitly stated that way in the draft that I have. I imagine, or I couldn't imagine, that DHCD wouldn't develop guidelines that would take something like that into consideration. But to the degree that that was a concern of the work group or the commission, I certainly don't think there is any harm in having some kind of means test as part of the grant process, and we can certainly include that in there.
Any other questions or comments? Okay. Seeing none, I think we have one proposal that was included in the packet, and I think it's only fair for us to take that up in consideration. The other two proposals were not given to you in advance, and what we have heard, I think, around those two is that there are recommendations for some additional work on both of them. But Senate Bill number XX, which was coming out of the work group established by this work group, and we saw the presentation from Joe and from Laura on, I think we can entertain some recommendations for the Housing Commission's meeting next month. Is there any motion on that particular proposal that was presented by Joe and Laura? Delegate Bulova.
Yeah, thank you, Madam Chair. And I think the conversation was extraordinarily useful. I think the conversation here has been useful for all three of these particular proposals. I think based on the scope of questions and some of the the confusion with respect to whether this does or doesn't usurp local zoning authority, or how this fits in with or exactly how we would need to go ahead and fix it to do what I thought I heard Joe Lurch say that they wanted to do. I don't know that we're ready to endorse it this time. And so I don't know that we need to take a vote, but if there's a procedure, a way of simply laying this on the table and appreciating the conversation for what it was.
Well, thank you. I think the motion would be that we don't recommend further action from this work group.
I could do that too, Madam Chair. Yes, thank you.
Is there a second for that?
Second.
Thank you. We have a motion to not take further action on Senate Bill number XX, but certainly an appreciation for all of the work that so many stakeholders have been engaged in. This is a topic that is of keen interest. I know I myself continue to receive questions from our constituents and community members, as well as from the media, and it is likely that one or two bills will be introduced this session. Knowing that there are some concerns, we will try to work and address those concerns prior to the start of session. So with that motion, all in favor, please say aye.
Aye.
Any opposition? And any abstentions? Thank you very much for all the conversation around this. We have one more item on the agenda, and that is the eviction diversion program, and that will be shared by Executive Director Elizabeth Palin.
Good morning, y'all. Morning, hello, afternoon. So you all should all be very familiar with the eviction diversion pilot program that we have extended several times and will expire this July. The eviction diversion pilot program was a program in the courts. We had 4 pilot courts, and it did several things. If a person paid at least 25% of the amount due on the unlawful detainer on the first docket call of the case, and they provided sworn testimony that they were employed and had sufficient funds to make the payments under a court plan, or they could get money for a nonprofit or elsewhere to make those payments. And they gave sworn testimony why they were unable to make their rental payments and hadn't been late within the last 12 months, et cetera, et cetera. This program has been gaining in success as it's been used. It hasn't been overwhelmingly used, but the numbers have been going up, and we've received a lot of phone calls from different courts throughout the Commonwealth saying, can we do this program? And we checked with the Executive Secretary of the Supreme Court, and there is no additional cost to implement this program. It is simply a district court judge can choose to offer this, that particular court can choose to offer the program and offer this to people who come in and on an unlawful detainer and offer them an option instead of being evicted. Is it a panacea for all evictions? No, it's not. Is it a step that is helping people, especially in Petersburg? We've seen it progressively. It's helping more people. And we hope that other areas of the state that have been calling, that they will implement it and more people will be helped. There's no cost, and it makes a program that we've endorsed as a pilot go forward throughout the courts in the state. And I hope you all would be in favor.
Thank you for that presentation. And I'm just curious, do we have data as to how the pilot program has affected communities and families?
So Jessica presented that at the last meeting before before she left.
Thank you.
And we do not have the data going forward since she has taken her. We don't have the data going forward since she's taken her sabbatical.
Okay, okay, thank you. Are there any questions or comments? Yes, Laura.
One question, Madam Chair. Elizabeth, I'm just curious about, though, the consequences potentially or the impact on the affordable developers. And so, I know in DC is a completely different animal, but just from some of the developers that I know have a presence in that market and also in Virginia, there are a lot of challenges associated with kind of moving the process of eviction. And so what ultimately happens is that those developers then have trouble operating the properties, and then that puts those properties in jeopardy, and then kind of impacts the affordability overall for all the families within that community. So I'm just trying to, I'm not as familiar with the program here in Virginia and not the impacts on the families and also on the developers, but just want to make sure that the developer community is also considered in this and not, the unintended consequence might be having an impact on the operations of that property.
So we would actually be thrilled, Madam Chair, if the program was being used to such an extent that developers were that impacted. This is for tenants that are evicted for extenuating circumstances. If they break their leg and they're a painter, if they had a second job and they lost their second job, they have to be able to pay 25% of the rent they owe up front, and they have to show, hey, I'm gainfully employed, I am going to be able to pay the rest, and here is the plan I'm showing the court. Ultimately, that landlord is getting more money than they would get if the person was just, the person has already been served with an unlawful detainer. The other option is to say, you're evicted, goodbye, go find somewhere else to live. I mean, just to be in the vernacular, just to be, give you that. So there's not a developer losing out of the program, and it has not yet been used because of the strict parameters of the program on a huge wide scale basis. But it has been effective where it has been used, and it has helped some families. We spoke with a judge here in Richmond District Court, and she has tried several times to implement it, but people have not fit within the guidelines.
Thank you, Madam Chair. Laura Dobbs with Homer, Virginia. Has there been any thought about revisiting the criteria for the program? Because I know it was initially intended to address a person who might have fallen behind one time, but when Home was administering Richmond's eviction diversion program, we had so many folks who didn't qualify because of all the categories. For example, number 6, that could not have exercised their right of redemption within the last 6 months. Just as a reminder for folks of what that means of the right of redemption, that allows a tenant to pay everything they owe, which at that point might also include court costs and attorney's fees, any late fees that have accrued, and any rent that has accrued since that initial filing. As long as they can pay everything at the court date, they can redeem. But by having this provision in here, we're it feels like we're punishing people who have been able to catch up before, but for some reason haven't been able to do it that other time. I support extending the sunset on this, but would love to see a revisiting of these criteria so that it's able to help more people. When we were administering it, we had to, fortunately, we had funding from the city to help provide some of that upfront cost, that 25% due at the court date. But oftentimes folks weren't learning about the program until they were already at court and didn't have the money with them. So providing a little bit more time to get the funds together, I think would help make this a more successful program.
Laura, those are all really valid points, Madam Chair, but the Virginia Housing Commission is all about compromise, and we worked with the Apartment Owners Association and the realtors and all the different parties together to come to this. And it doesn't mean just because we extend this program and allow it to be an option for different courts that we can't move forward in other areas to come up with great eviction diversion options, or that can't be incorporated at a different point in time. It's just not part of this particular bill at the moment.
Thank you. And I see a hand up, but I can't see who's, okay, Renee, thank you.
Thank you, Madam Chair. Renee Pulliam, Virginia Apartment Management Association. I operate properties in 2 of the localities that were part of the pilot program, Richmond and Petersburg. And the original language on line 32 stated, under the pilot program, a tenant in an unlawful detainer case shall be eligible to participate in the program. Some language is added here in this draft, which changes shall to may, and then adds the language at the discretion of the court. And that is where the problems with this program lie. In theory, having a program that gives tenants an opportunity to get back on their feet and stay in their housing is a good idea, and we do agree with that. I have properties that have experienced situations where the judges will not follow this law and not require that the 25% be paid at the initial return date. And on the the next page, lines 57 through 61 outline the basically court-ordered payment plan, when the preceding 75% of the balance would be due. And it indicates due by the 5th day of the month, on subsequent months. I'm paraphrasing. I've seen judges cross through that language and give people arbitrary due dates on their payments. And while I have seen some success with the program and individuals that have been able to pay, when the judges arbitrarily go against what is written here, they are ultimately adding time on, in the instances that I've just described, they're adding time onto the payment plan, and that really kind of flies in the face of what this is intended to do. So adding the language may and at the discretion of the court, I see that as problematic because that gives judges in writing the ability to have discretion when they already were and in the pilot program.
So Renee, we asked for the courts may choose if they want to participate. We would be comfortable with having it back. They shall be eligible to participate. That isn't something we anticipated on changing. And if the judges don't comply with the law, that's a whole different situation than we're looking to address with this bill. And it goes far beyond the scope of what we're looking to solve.
Delegate Bulova.
Just so I understand what Elizabeth was saying, so are we proposing to completely undo lines 32 and 33, so the tenant shall be eligible to participate in the program? Okay.
That's how it read initially for the pilot, and we did not actually request that to be changed.
Okay. Right. And I guess, Madam Chair, and I'm fine with that. I thought it was odd that we were making it
Yes.
just discretionary. I think it is a different issue with respect to whether a judge actually abides by that language, because this language deals with the tenant, whether they may or may not be eligible. I think the language that you were citing, judge, regardless of this language, has to abide by the code. So I'm not quite sure how we fix that, but don't have any problem making the shall or the may to shall here.
Delegate Volova, Madam Chair, I think the issue might have been that said that wanted the program, the courts to determine whether or not they wanted to participate, meaning does City of Richmond want to participate? Does the localities to participate? And I think there was a misinterpretation of what I'd asked.
Are there any other questions or comments? Yes, Bisma.
Thank you, Madam Chair. Bisma Ahmed with AOBA and VAMA. Just to kind of echo Renee's comments here, we like to have a mechanism in place like this as long as it's being utilized as it's supposed to. We've talked to some of our attorneys and we're hearing their experiences have actually largely been negative in terms of judges just kind of disregarding the guidelines on this. So she mentioned the example of judges not requiring that 25% down at the initial return date. That's we're hearing things like this. So as I mentioned, just wanted to put it on the record, we support these programs as long as they're not being abused. So at this moment, we do have some concerns.
Thank you. Any other comments or questions? So we have this particular legislative proposal in front of us. Is there any motion on a recommendation to the full Housing Commission next month? Delegate Bulova.
Madam Chair, I would move that we forward this on for endorsement to the full Housing Commission.
Second.
It's been moved and seconded that we recommend this to the full Housing Commission next month. Any further discussion? Seeing none, all in favor, please say aye.
Aye.
Any opposition? Any abstention? One abstention. Okay, thank you. All right, we had a long agenda, and I appreciate everyone's patience and all of the quality of questions and discussion. We do have public comment at this point. Public comment, and if you wish to make a public comment, we are going to ask you to keep your comments to 3 minutes. And please come on up. And there may be some online as well, which we don't do that. Okay. Thank you. Please go ahead.
Madam Chair, Panagiotis Yanakouros from Harrisonburg. I'm here also with Bruce Ritchie from Shenandoah. We are here with language that we think may address a source of housing precarity and a number of collateral consequences. It is a proposal to repeal enabling legislation for tall grass and weed ordinances. Tall grass and weed ordinances emerged as general purpose tools for pressuring people out of neighborhoods, and they continue to retain those properties. Turf grass in particular is a good proxy because it grows constantly, and an aesthetic complaint about that is something that somebody can wait around and plausibly make, potentially. I would suggest that repealing that ability may open up new possibilities for more targeted and appropriate tools for anything that is a legitimate concern, and they can start to address the collateral consequences of environmental justice issues, stormwater runoff, and many things that we've been hearing in other committees. So I thank you for your time, and this is available for anybody who's interested in that issue in the commission or the audience.
Thank you, and I believe you also forwarded it electronically to all of our commission members. Is that correct?
To the chair.
Okay, thank you. Are there any questions? Okay. And I have a question. There was a legislation last year, am I correct, that was introduced?
Yes, we dealt with HB 528, which set out to protect natural landscapes in the context of homeowners associations, but there was some complication there. We had concern because a definition might have had implications for this issue, for how the General Assembly would deal with ordinances. It was kind of putting the cart before the horse. This starts with the ordinances, and then if at the level of contracts and property, a community or a person wants to find something more selective, that can be left for discussion. I might still argue that the public purpose that's emerged with growing weather issues and housing precarity, even there would suggest that the whole thing be left to goodwill and persuasion and education.
Okay, thank you. Thank you very much. Are there any other members of the public that wish to speak? Seeing none, thank you again for all your patience. I hope everyone has a wonderful Thanksgiving. Is there a motion to adjourn? We are now adjourned. Thank you.